Physical mention. Item number 2. Mr. Digant Das.
Notice under 148/30 assessment is 1314.
Where's
By a
Mr.
lot.
Satpathy or Mr. Mahapatra or somebody?
As Mr. Satpathy has some problem, he'll be a little bit late.
Number 1.
An encroachment proceeding was started against me. Then I filed an appeal. I was directed to be evicted. It's my purchased land. And then I filed an appeal and finally I went to revision. Revisional authority allowed me revision and directed the encroachment proceeding to be dropped. So I filed a writ petition before this honorable court saying that since the revisional court has already held in my favor, let a patta be granted in my favor. In the meantime, because of some disturbance to my possession, I filed a suit. Then a single judge says, since the suit is pending, this will not be granted. This is a different grant of patta pursuant to the direction of the commissioner.
No, but I think in the suit you went and asked for declaration of title.
Yes.
So if your title itself is in doubt, why will they grant you a patta?
Already the RDC has, the revisional authority has already granted, dropped the encroachment case and directed that patta should be given. I only wanted.
So why didn't you withdraw the suit? Then that all your problem would have been solved.
My lord, suit is disposed of. Suit is dismissed. It is confirmed by the appellate court. You also see the impugned order here. It is confirmed in RFA number 20 of 2013. So naturally, the civil court decree will prevail upon this revenue court's order. Civil court has declared.
What has the civil court done?
Civil court has declined to pass a decree for declaration of right title interest. In that event, how the revenue authority can...
Virtually a suit for possession because somebody has disturbed my possession.
No. What did you do with that? When that went against you, what did you do?
Appeal.
No. So the appeal was dismissed.
That's what my friend is saying. I didn't.
How no, that
not
is
there, sir.
impugned order.
Impugned order is there. That's
I'm not saying.
But my contention is only because this issuance of patta pursuant to the direction of the RDC's the revisional authority's order is to be there. That nothing more. I have not asked for. I only wanted implementation of that.
No. If they are aware that your appeal was dismissed, why would they grant you a patta?
No, what? But this order still remains. No,
but an authority is faced with two things. One is no declaration of title.
Right, in the circumstances, I would pray that your lordship may permit me to withdraw this appeal and proceed with the pursue my remedies with the Tahsildar.
All right. Whatever. That's the chance that you take. All right. Counsel for the appellant seeks leave to withdraw this appeal with liberty to pursue his remedies before the Tahsildar in accordance with law. Disposed of is withdrawn with liberty is prayed for. All right.
Item number 2.
May I please?
Yes.
Last occasion, your lordship had accommodated me.
Yes.
But in the meantime, I have undergone a leisure some operation, but yet I am ready because it's old matter.
All right.
But in case of any difficulty, your lordship may kindly accommodate.
All right.
Because I'm undergoing some treatment, giving some drops, so there is some haziness. May I please? Here the annexure 1 is under challenge before lordship, passed by the honorable single judge. Page 15, and the order person is page 70.
Right.
May I place the order, madam?
Yes, please.
The petitioner has filed this petition seeking to pass the letter dated 26/2/2017 along with his annexure by annexure 12, by which his representation for consideration for appointment under the reproduction assistance scheme in the bottling plant of the opposite parties number 1 to 4 has been rejected, and further seeking for a direction to give such appointment as his father is the land austee in conformity with the scheme. So this is important, madam. In conformity with the scheme, the factual matrix of the case in hand is that opposite party number 1 into an agreement on 12/12/86 for acquisition of land in village Bamanda and Chandpur in the district of Baleshwar for establishment of LPG bottling plant by Indian Oil Corporation with the collector, Baleshwar, opposite part number 5. As per the agreement, it was decided that each land loser family and their nominee will be provided with a suitable job in the bottle plant of the opposite part number 1. The state government acquired land in Moja, Chandpur in the district of Baleshwar in the year 1988. In the said acquisition, 0.65 decimals of only agricultural land of one Akshay Kumar Das, the father of the present petitioner, was acquired. Consequently, the father of the present petitioner is a land loser. Therefore, after the land was acquired, the plant manager, opposite part number 4, requested the collector Baleshwar to send the names of the land loser so that steps can be taken for the appointment of suitable persons for each land loser family. The petitioner's father, who is an old illiterate scheduled caste person, being Dhoba by caste, sought for appointment of the petitioner under the reproduction assistance scheme because of the acquisition of his only agricultural land measuring 0.5 for establishment of bottling plant of opposite part
No,
number
so
1.
are you agreed by the CBI inquiry or?
Yes, CBI. There is no basis, my lord. The entire impugned order is based on error of record and without any justifiable reason.
No, but sir, there are two directions.
Yes.
One is asking you to investigate, right?
My lord?
There are two directions. In para 7,
My lord.
it is necessary the investigation should be conducted. Okay.
Yes.
Ah.
So there is no basis. My lord, your lordship knows in what circumstances CBI has inquiry
So
is
no
being done.
relief was granted to the petitioner, but a CBI inquiry was ordered.
Yes. CBI, blood,
Not for compassionate appointment.
the company,
Who's-
he is not
who's-
entitled. He is not
who's the-
entitled.
All right. Was there a stay granted by this court?
Yes. And I think a report has, in the sealed cover, a preliminary report or initial report.
Just examine.
Preliminary report is there.
All right. We'll just.
And the company is nowhere, they are not the public servants, my lord. They are the company and they are discharging duty as an employee. And here the entire order with my lord with completely based on error of record and also without any justifiable reason. In an envelope it was there.
But I am appearing for the respondent number 1, read petitioner. My preliminary objection is the writ appeal is not maintainable as because it is not a judgment. And
No. There is a direction and it is adversarial to them.
Yes.
no, my lord, my submission is by the impugned order, which is appeal, the right title interest of the parties are not taken away. It is just calling for a
No,
report.
but it's a
So it is not a judgment, not appealable at all. In that respect, my lord, I have a direct decision of the apex court.
All right. All right. We'll examine that.
My lord.
Sir, how do you say they're not affected?
My lord.
They are the Indian Oil Corporation.
My lord.
The single judge says that your method of granting appointments under your rehabilitation scheme is faulty and a CBI investigation should be ordered into it. Why would Indian Oil not be affected by it?
My submission, my lord, it is a corporation. Under this scheme, they have to give appointment. Because there is illegalities and irregularities giving appointment, the single judge has directed for CBI inquiry. So if inquiry may come in our favor or in their favor. So how can they anticipate that it will come in our favor?
I never
So by that
anticipated.
process, they are not agreed.
No,
And
no.
furthermore, it is not a judgment. Unless it is a judgment, then no appeal under letter patent is maintainable, my lord.
Let me just read the conclusion of this
My lord,
inquiry.
my lord.
I think this is nothing secret about it. No quid pro quo financial transactions between the said 7 ineligible candidates and IOCL officials or state government officials surfaced during the inquiry.
My lord.
I think this should put a quietus to the entire thing now. Neither your objection is valid nor his apprehension is valid now.
No, we had no apprehension at all. My lord said what is not wholly correct.
No, but anyway, this report is not
Yeah,
negative.
it is unnecessary abuse of the process of the investigation agency.
Anyway, all that is over
Yes,
now.
yes.
All right. You say the report dated 21st December 2017 of the Central Bureau of Investigation, bracket CBI, which was placed in a sealed cover before this court, has been perused. The operative portion of the said report, which is in para 5.9, reads as under. Reproduce the whole of para 5.9. In view of the above conclusion of the CBI, the directions issued by the learned single judge in the impugned order have worked themselves out without expressing any view on the appropriateness of those directions issued by the learned single judge, which were questioned in the present appeal, and without any expression of any view by the court on merits, the appeal is disposed of.
One thing I pray, my lord, the matter is of 97 and one is 23. The lordship direct to place before the honorable single judge for hearing. The writ petition is pending, my lord. One is 97 and the other is 2008.
All right.
No, what my lord, I think this
What's going to come of all this, sir? Nothing is going to come of it anyway. But we are not concerned with that because what is before us is only this appeal.
Exactly.
Yeah.
But I don't know why submission is made. That will come in user course before the user.
Correct. You see in both those OJCs and writ petition civil placed before the learned single judge in the roster bench on 4th January.
My lord.
Right. You want a copy of this report? All right.
No.
A copy of the report be furnished by the registry, both to the
My lord is.
counsel for the appellant as well as the respondent.
Much
All right. All right.
Item number 3.
My lord, connected matter, your lordship, writ petition, writ appeal number 512 of 2016, your lordship disposed of, holding that the order passed by the Tahsildar is an appealable one as it is held by the honorable single judge. My
All
lord.
right.
And directed that appeal should be filed by 5th of month in the connected matter. Your lordship may in this case, my lord, kindly grant 10 more days time,
All right.
15th December.
All right. Counsel for the appellant seeks leave to withdraw this appeal with
No, my lord, has disposed of.
All right.
Item number 4.
1 minute.
And delay to be condoned, your
All
lordship.
right. Delay is condoned. Same order.
No, my lord.
Delay in filing of the appeal.
Filing appeal, as your lordship.
All right. All right. All right.
Same order may be passed
All right.
only by changing the date.
Correct.
Yes.
The challenge in the present appeal is to an order dated 19th October 2016 passed by the learned single judge in 17796 of 2016 on the ground that there is an alternative efficacious statutory remedy of an appeal against the order dated 8th September 2016, right? No, 23rd July 2016, passed by the Tahsildar. All, AUL, dropping the proceedings in view of the pendency of a civil suit, being CS number 10/2016 in the civil court. Paragraph, having heard learned counsel of the parties, the court is satisfied that the aforementioned order dated 23rd July 2016 is in fact an appealable one under Rule 92 of the mutation manual. Paragraph, the court accordingly finds no error having been committed by the learned single judge requiring interference. The appeal is accordingly dismissed. If the appeal is not later than 4th January 2023, then the explanation offered for the delay on account of the pendency of the writ petition, as well as the writ appeal, will be taken into account by the appellate authority in accordance with law.
Obligement.
Item number 4.
My lord, before taking over a matter, my lord, I will finish within 5 minutes. I request my friend not to disturb. In the last occasion, we class each other, my lord. So before taking off, give me some space. I will comfortably place my matter.
May I place one thing? Mr. Khuntia is supposed to conduct this case. He is not today available. If they can dispose amongst themselves, the matter can be disposed of. If something has to say on behalf of the state government.
My lord, subject to his only on point of law matter is to be decided. No factual controversy is required. We are admitted the facts. if Lordship will any factual controversy will arise,
Now, only
Then
thing
matter can be-
my response
matter can be
is
answered.
that if any government role is there, I don't
Well,
have any idea about this file. If any government role is
Or-
there, then
So let him place it. And
yes,
Madam.
All right.
Well, before going into entirety into the brief, my lord,
Yes.
I am stating the brief, my lord.
Yes.
Now, the college was established in 1985, my lord. At the time, it is a private college.
Right.
My lord, the appointments for teaching and non-teaching staff was selection was held. Appointment orders was given in one date to the teachers and peons, my lord.
Hmm.
But this is the on record, my lord. I am not go beyond the record. 3 peons were appointed, my lord. The subcommittee, my lord, selection committee recommended 3 names. At the time of approval, my lord, no seniority was determined, my lord. Then, my lord, when the college become eligible to grant in aid, what they have done, since there is no rule, no instruction, my lord, on basis of joining time, the one Kuramani Rahul was recommended to get the grant in aid. This is not a case of promotion. This is only dispute regarding receiving grant in aid. 2 peons will get grant in aid, 3rd peon will get block grant. No question about the promotion is concerned for the post of peon, my lord. Then, my lord, I went to this honorable court, my lord. This honorable court directed that the director to consider my appeal. The director, my lord, has taken the view that since both the 3 peons have joined in one day, in absence of rule on executive instruction, the age will be the criteria, my lord. Then that dispute again went to the regarding granting aid to the education tribunal and before this single bench, my lord. Single bench, my lord, has taken the view that on basis of merit recommended by the selection board in 1985, that is to be the principle in the seniority, my lord. My case is that since both 3 have joined in one day, the date of birth or age is only the criteria. I have in support of that, I brought 3 decisions on this point, my lord. If Lordship will permit me, I'll go to the facts. I am not disputing any facts, my lord. No instruction, no rule, my lord. I'll simply place 3 judgments. If any factual controversy will arise, I'll place, my lord.
All right.
My lord, I have given the last date given the judgments, my lord. Again, also today giving, my lord. My lord, the 2011 judgment, my lord. That is same principle. (2011) judgment, I am again giving that date chart and judgment, my lord. That DP Das case, my lord. 2011, my lord. Well, let me come to paragraph 23.
The Supreme Court and
The
MB
Supreme Court
Joshi.
MB Joshi case,
Ah.
Satish Kumar or Satan Sat has laid down that it is well settled that principle of service rule then, in the absence of any specific rule, seniority among the person holding the similar post in the same cadre has to return on basis of length of service, not any other factual circumstances, my lord. Then, my lord, then paragraph 27, my lord. In the instant case, no record has been brought over before the court to ascertain the merit-wise position of the person who have directly recruited, except memorandum 46, which is still in force. No other rule, executive instruction has been shown to apply to the fact of the case.
No, but in your case, your merit-wise position is known.
My lord, I am coming, my lord. My lord, this court has held, in absence of a rule, my lord, if all the incumbents join in one, age will be the criteria.
No. Where is this para you're reading is not about
My lord,
running the
I'm
same way.
coming. Again, not completed, my lord. Then there also come to 34, my lord. That is MB Joshi case, my lord. MB Joshi case is different.
So this judgment has not
34, my lord. Page 34. I am coming. All 3 judgments have come. For the reasons above, court hold that determination of seniority of officers who have recommended on the same date, age is the only valid and fair basis. As such, the seniority should be decided on basis of age candidate who have recommended. My lord, this MB Joshi also I have brought, my lord. MB Joshi, my lord, same date contingency was not there. So, the length of service was taken into account. They have taken into account, my lord. Then MB Joshi, my lord, I have also brought that MB Joshi because that one day criteria was not there. My lord, MB Joshi also come to page 13. It is further important to note that in cases where the government itself has been adopted the practice by making promotion as contended by the applicant, you are upholding the practice. In Suresh Nathan case, 92 Supreme Court also court upheld in the practice followed by the government. It is well settled principle that the solution that in absence of a specific rule, seniority among the person holding the similar post in the same cadre has to determine on the basis of length of service, my lord, because one day contingency was not there. That is MB Joshi, my lord. Then you have to come to 88 Supreme Court, my lord. That is Sudhma Singh, my lord. That is page 87. Also got it. 87, my lord. Paragraph 8, last part, my lord. That was underlined. If two and more teachers are appointed on the same date, seniority should be determined on basis of age. My lord, this is the law, my lord. Because in Joshi case, one day criteria was not there. So considering both the decision, in the latest decision, the court has held that since they have joined in both one day, my lord, age will be the only criteria, my lord. Because in absence of rule, three option will be available. One is merit, another is length of service, then, my lord, the age, my lord. These will come into force, my lord. My lord, what the college has adopted length of service by considering the joining time. Because the joining time, same day, they have given 2 dates. That is also a manipulated record, my lord. Joining time. Then, my lord, come to the director. Director has held that age is the criteria, my lord. And that was upheld by the education tribunal. But court has gone to the merit, my lord. That merit was nowhere, neither governing body nor any state functionaries have accepted that, my lord. Rather, governing body in 2002 accepted the age will be the criteria. Government, the managing committee resolution is there, my lord. That is my case. Then my lord, in this case also 2011, the court has specifically stated that when there is no rule, no instruction, the court has to be absorbed. A fair and reasonable criteria has to be absorbed by the court itself. That in 2011 decision, that has been specifically stated that court has to absorb a principle. That somewhere I have read that is duty of the court, not the executive, my lord. Because they have 3 options are available. They can adopt any move, but court has to take a conscious view.
So you have to answer the main question that that is posed by the single judge's order. It is pointed out that there were 3 posts. The first post, as far as Kulamani Rao is concerned, it was filled on the basis of merit, sir. It was not filled on the basis of age or senior and all that.
The selection was made on basis of a subcommittee.
So once the criteria is fixed that I'll fill up the post by merit, you can't do that. You can't say for the first post.
There is no rule how to determine the criteria. So in the absence of rule, age will be the criteria. And that has not been. It has not been accepted by none. First, the governing body recommended in the one basis of length of service, putting the joining time, my lord. Then come to the director. Director determined the age. Education tribunal taken view that age. Court has gone to that merit of the select.
Because all 3 posts had to be filled up, sir. It can't be that post one. It can't be that for the post number 1, we will appoint on merit. When it comes to post number 2, we'll go to date of birth. How can it be?
My lord, the 1 and 2, my lord, even if the merit is, even if your lordship will held that it is a criteria, my lord, nowhere there is in the rule nor in instruction, my lord. So,
How can, say the selection is held, sir.
my lord, selection is held.
So what?
Eliminate, my lord.
Based, if it is all to be based on seniority or just a date of birth criteria, as you are suggesting,
My lord.
why is the question of a selection at all then?
My
Why
lord,
have a selection?
Select-
Why have a selection?
My lord-
Why have a grading?
My lord, selection is to eliminate, my lord.
You
Ah.
participated in the selection,
My
sir.
lord.
Now you can't turn around and say, no, selection should not be the criteria. Merit should not
My
be the
lord,
criteria.
they have, in case of teachers, my lord, they have adopted the age is the criteria, my lord. I have given in affidavit.
So you participated in the selection.
My lord.
Once you were second in the merit list, now you're a third.
Third.
Because you're third in the merit list,
My-
now you're questioning it.
My lord,
Are participating.
my lord, determinants of seniority, my lord, there is no rule, my lord, no instruction, my lord. So they have, for teachers, my lord, I have filed the additional affidavit last date. For teachers, they have adopted the age is the criteria, my lord.
Yes.
Additional affidavit I have filed last date. I have given that circular, my lord. That is the only circular in the field. Last date I have given the additional affidavit. You also come to that affidavit, my lord, that is 82 circular, my lord. Let's you got it. Additional affidavit filed on last date, my lord. But that 82 circular says last part, in case of two candidates joined in same category 1, 2, 3, 4, their interest seniority may be fixed in accordance with date of birth, older candidates being placed above the younger one. In case of teachers, they have done it, my lord. Same college, my lord. In the same day also, 4 to 5 teachers have
Have you
joined.
seen his affidavit?
My lord, he has denied that he has, I've seen, my lord. He has denied.
No. According to you, there's no rule. He's pointing out a government circular 211082, which governs.
My lord, he has filed the objection that there is no rule, no instruction, my lord.
There is. He's filed an affidavit.
My lord, I have received, my lord. I have received. I am not disputing that.
Then
I am not disputing.
no, what is your answer? He's pointed out to a government circular.
My
It
lord,
says the appointment will be on merit.
He has stated that there is no instruction, no rule. I have stated that for same institution, there is an instruction for teachers, and that they have adopted for teachers. That is my submission, my lord.
So you're peon, you're not teacher.
That is also against him.
Ah.
Lordship may kindly see para, my lord, Roman 3.
Where are you reading now?
No, Roman 3 of that circular.
From which document, sir?
My lord,
From
that-
which document?
That affidavit which he has filed, relying upon that
Flag white.
government circular dated 211082. My lord may kindly see.
Flag white.
Roman 3, the last page. In case of appointments made on the recommendation of the selection board between 1st December 76 and 23rd October 81, the inter-se seniority may be fixed in accordance with the position assigned to them by the selection board in the merit list. But this is per se not applicable to the non-teaching staff because this is meant for teaching post. You will also may kindly see the first paragraph of that circular. The Orissa Aided Educational Employees Common Cadre and Intertransferability Rules 1979. Implementation thereof in case of aided college teachers under direct payment.
Correct. It's for teachers.
Teachers. And my lord, my next point before your lordship is the director on his own decided that on the basis of date of birth, inter-se seniority will be determined. Your lordship rightly put the question to him that so far as Pulamani Raul is concerned, he is the junior most so far as age is concerned. My lord, may kindly see that. In my counter affidavit, the Leonard Single Judge has taken note of that.
Correct. So he should have been post number 3.
He has been appointed against the first post.
And he has not challenged that.
Yes.
He has not challenged that.
And he has been appointed and he has been approved against the first post. So never, what my learned friend argued before your lordships, that on the basis of date of birth, my lord, approval was made. That is not correct. And Learned Single Judge has reiterated that. And my lord, I am citing two judgments. Your lordship may kindly speak it. My lord, my first point before your lordship is this writ appeal is not maintainable because your lordship knows about section
Education
100A of the
tribunal, single
CPC
judge.
that
Yeah.
undergone an amendment against the order of the appeal. My lord, he has filed the letter patent appeal. So on that, my lord, I am citing one judgment. Your lordship knows that.
Full bench of this court.
Full bench and other things, my lord, I have. Your lordship knows it. Then so far as the merit of the case is concerned, my lord, your lordship is absolutely right that where selection has been made, the position in the merit list will determine the seniority, not on the basis of date of joining.
Right.
And here the peculiar facts, sir, my lord, all the 3 persons joined on the same date.
Correct.
My
So
lord,
one came on merit.
Yes.
You're saying why? How can position number
Yes,
two
yes.
not be on merit and
Yes,
date of birth?
Yes, my lord, I am citing only 2-3 judgments. I will close my argument. My lord, may kindly see.
It's only on merit.
2007 1 Supreme Court cases, page 405. Your lordship, may kindly come to paragraph 7. Here. Paragraph 7 and 8. This court in Chairman Puri Gramya Bank versus Ananda Chandra Das held as follows. This appeal arises from the judgment of the High Court of Orissa in OGC number such and such. The respondent and others were selected by direct recruitment as managers of rural bank. His rank was 9 in the merit list. He was directed to be given seniority on the basis of date of his reporting to duty. It is reported that the first respondent is dead. The only question in this case is that what shall be the ranking among the direct recruits? Is it the date on which they joined duty or according to the ranking given by the selection board? On comparative evaluation of the respective merits of candidates for direct recruitment, the board has prepared the merit list on the basis of the ranking secured at the time of selection. It is settled law. If more than one are selected, the seniority as per ranking of the direct recruits, subject to the adjustment of the candidates selected and applying the rule of reservation at the roster. By mere fortuitous chance of reporting to duty earlier, would not alter the ranking given by the selection board and the arranged one as per roster. The High Court is therefore fully wrong in its conclusion that seniority shall be determined on the basis of joining reports given by the candidates selected for appointment by direct recruitment and length of service on its basis. The view therefore is wrong. However, we need not interfere with the order since the first respondent has died. Then paragraph 8. Since there was no rule in operation, obviously the ranking in the merit list was to decide the respective seniority. The ratio in Chairman Puri Gramya Bank case has full application to the facts of the case. The applicants claim that he was to be treated as senior and other things are not relevant. Then another judgment, that is the Bimles Tanwar, on the same line. Your lordship may kindly come. Paragraph 53. Here also relying upon that Chairman Puri Gramya Bank case. Paragraph 52. In this case also, although there does not exist any statutory rule, but the practice of determining inter se seniority on the basis of the merit list has been evolved on interpretation of the rules. A select list is prepared keeping in view the respective merit of the candidates. Not only appointments are required to be made on the basis of such list, seniority is also to be determined on that basis, as it is expected that candidates should be joining their respective post almost at the same time. Yet again in Chairman Puri Gramya Bank case that has been quoted. So this has been consistently followed by the Honorable Apex Court. But my learned friend is citing judgment where selection has not been made. In those cases, length of service will be. And here, my lord, all the 3 peons joined on the same date. And what my learned friend says that on different times, that 1:11:30, 1:11 and 1:11:15, that is all correct. And Kulamani Raul, who is the junior most so far as age is concerned, he was appointed against the first post. His appointment was approved against the first post. And another aspect the learned single judge has considered that the director has no jurisdiction to pass that order because he was prevented to discharge his duties, which tantamounts to termination of the service. He approached this honorable court. This honorable court directed the director to take a decision on the question of his prevention. Last occasion, my lord, I cited the circular of the state government dated 27/3/83, where, my lord, service is terminated arbitrarily in case of an employee of an unaided institution, appeal lies to the director. So director was supposed to decide the question of termination. He has no jurisdiction to determine the intercessionality. I have cited number of judgments of this honorable court. The director lacks the jurisdiction to decide the question of intercessionality.
All right. Yes, sir.
My lord, I am again pressing my lord that 2011 judgment, my lord. That is, the lordship will find what my friend is.
Rajendra, which is that? Rajendra
DB
Singh.
Das, my lord.
Huh?
DB Das, my lord.
DP Das.
My lord. Page, my lord, in paragraph 24,
Right.
that is a case, my lord. Selection made by the EPSC, merit list was drawn. Thereafter, this contingency was arised, and one day contingency was there. In paragraph 24, determination of seniority is a vital aspect of service. Career or employee, his future promotion depends on this. Therefore, determination of seniority must be based on some principle which is just and fair and mandate of Article 14 and 16, my lord. Paragraph 24, my lord.
Right.
Then, my lord, paragraph 25. The manager government branch press another DB Valley 79 Supreme Court, 3-bench court, this court constitutional Article 14 and 16 interpreted equality clause of the Constitution. The executive is no less than judiciary, is under a general duty, act fairly. Indeed, fairness founded on the reason is the essence of the guarantee epitomized in Article 14 and 16. So, in these cases, my lord, contingency, my lord, court has a duty to make a fair and equitable decision whether it will be merit or age or length of service, my lord. It is duty cast upon the court, my lord. My lord, what my friend has cited, my lord, that one day contingency was not there in that judgment, my lord. That there is a selection board, and so that view of the matter, the court has resorted to that the merit criteria, my lord. This is the case, my lord. There is no rule. My lord, no rule, no executive order, my lord. So this is a case, court has to play whether what would be the fit, my lord. Whether merit or length of service, and that one day criteria, my lord, only that available in 2011 and 880 Supreme Court, my lord. So, taking to that view, my lord,
All right.
my case can be considered for a release of granted against this second post, my lord. That is my view. And so far as the other technical points, I will not. The power of the director and other authority, my lord, it is upon the court, cast upon the court to formulate a policy.
The a dispute concerning the inter-se seniority of two peons of the PBM Mahavidyalaya bracket respondent before forms the subject matter of the present appeal, which arises from a judgment dated 3rd November 2016 passed by the learned single judge in FAO number 183 of 2011 and OJC number 399 of 2002. Full stop. Paragraph. The background facts are that the said educational institution was established in 1985 for +2 courses. Full stop. On 15 July 1985, an advertisement was issued for filling up of 3 posts of peons in the said institution. Full stop. Admittedly, on 27 July 1985, a subcommittee, which was the selection committee, met and evaluated the capabilities of 7 candidates who appeared before it. Full stop. These 7 candidates included one Shri Kulamani Raul, as well as the present appellant, Shri Loknath Barik, and respondent 1, Shri Basanta Kumar Barik. Full stop. On 30th July 1985, on the basis of the mark sheet drawn up by the said selection committee, the governing body decided on filling up the first post of peon with Shri Kulamani Raul, who admittedly was first in the merit list. Full stop. The further admitted position is, while respondent number 1 was in the second position in the merit list, the present appellant was the third position in the merit list. Full stop. Both the appellant and respondent 1 were appointed as peons on 30th July 1985, and both of them joined on 5th August 1985. Full stop. As far as Shri Kulamani Raul was concerned, he also joined on 5th August 1985. Full stop. Paragraph. The counsel for the appellant emphasized that while Kulamani joined at 11:10 a.m. on 5th August 1985, the appellant joined on the same date at 11:25 a.m. and respondent number 1 on the same day at 11:45 a.m. So, paragraph. The further admitted position is that the PBM Mahavidyalaya became eligible to receive single courts grant in aid, unquote, with effect from 1st June 1994. Full stop. At a stage when the issue of approval of the 3 posts of peons and release of grant and aid was pending before the Director of Higher Education, the present appellant filed OJC number 14919 of 99 in this court. So the said writ petition came to be disposed of by a learned single judge on 8th May 2001 with a direction to the Director of Higher Education to dispose of a representation dated 6th March 1998 filed by the present appellant. A further direction was issued that while disposing of the representation, open quotation, the director shall look into the documents produced by the petitioner as well as the annexures filed in this writ application. Full stop. Following the above order of this court, the Director Higher Education on 18th December 2001 passed an order treating the appellant, second peon, for the purpose of the grant in aid. A perusal of the order dated 18/12/2001 of the Director Higher Education, Orissa, reveals that the director disapproved of the select list prepared by the governing body. Held that the selection list prepared by the governing body was not correct. Full stop. Further, going by the date of birth of the three candidates, it was opined that the appellant herein, that is Sri Lokanath Barik, was entitled for the post of second peon in the college. Full stop. Agreed by the above order passed by the Director Higher Education, Orissa. Respondent 1 filed OGC number 399 of 2002. So on 31st December 2002, the governing body of the institution passed a resolution fixing the inter se seniority of the appellant and respondent 1 as second and third peon respectively, as per the joining time of each of them. Paragraph. Following this, respondent 1 filed OGC number 590 of 2005, claiming that he should have been appointed to the second post of peon. Stop. He sought the quashing of an order dated. It's an order, this 15 July or is an order. What is that order dated 15 July 2004, sir? Mr. Swine, it's there, Annexure 10.
That is the order passed by the State Education Tribunal.
15 July?
No, sorry.
Director. It's an order passed by the director.
Order passed by the director.
The above order dated 15 July 2004 of the Deputy Director, Department of Higher Education, was to the effect that the approval order issued in favor of respondent 1, as second peon of the institution, for the purpose of extension of benefit of block grant, open quotation, is hereby cancelled, unquote. Paragraph. Following this, respondent number 1 filed GIA case number 83 of 2008 before the Education Tribunal. Full stop. This case was dismissed by the Education Tribunal on 1st March 2011. Full stop. The said order was challenged by the respondent number 1, who filed FAO number 183 of 2011. Paragraph. The learned single judge has, by the impugned common order dated 30th November 2016, disposed of both the aforementioned OJC number 399 of 2002 and FAO number 183 of 2011. The learned single judge noted that of the 3 posts which were to be filled up by a process of selection, the first post was filled up by Shri Kudabrina Raul on the basis of merit. So stop. Since that was the criteria, even for the post, second and third posts, it is merit that had to be the criteria and not the date of birth. So on that basis, the plea of the respondent number 1 herein was accepted, and a direction was issued quashing the aforementioned order of the director and also the order of the corresponding order of the Education Tribunal, confirming it. Full stop. A declaration is issued that respondent number 1 herein was senior to the present appellant and would be entitled to all benefits, service benefits attached to the second post of peon in the institution. Paragraph. While admitting the present appeal on 15 January 2019, it was directed that in the meanwhile, status quo as of that date regarding the service condition of the appellant as well as respondent number 1 shall be maintained. Paragraph. IA number 755 of 2021 was filed by the present appellant for a direction to the state government not to release arrears in favor of respondent number 1 during the pendency of the writ appeals. Paragraph. On the said IA, notice was issued by this court on 25th August 2021. Paragraph. This court has finally heard the submissions of counsel for the parties. Counsel for the appellant. No, before that, you say, as far as pleadings are concerned, the appellant filed an affidavit dated 26th October 2022, inter alia, placing on record a government order bracket GO bracket number and dated 21st October 1982, which according to the appellant should govern the situation. Since according to the appellant, since both he and respondent 1 joined at the same date, that is 5th August 1995, in terms of the said GO, it is the older among them who should fill up the second post of peon. And therefore, the appellant should be declared senior to the respondent 1. Paragraph. It must be mentioned here that today, respondent 1 has filed an affidavit dated 25th November 2022 in purport reply to the above affidavit, additional affidavit of the appellant. Intelliates pointed out that even in terms of the said government circular dated 21st October 1982, which in any event has, according to the respondent 1, no application to non-teaching staff of non-government aided colleges, wherever a selection has been made even for filling up a post of non-teaching staff, it is the position in merit that will determine the inter se seniority. Stop. It is pointed out that the same circular dated 21st October 1982 clarifies this. Paragraph. Counsel for the appellant placed extensive reliance on the decision of the division bench of this court in DP Das versus Union of India, 2011, 2 OLR SC 728, and in particular, the following passages. The following observations. Full stop. It may be noted that the said judgment in turn refers to the decision of the Supreme Court of India in M.B. Joshi versus Satish Kumar Pandey, AIR 1993 SC 267, which held that in the absence of any specific rule, the seniority amongst persons holding similar posts in the same cadre has to be determined on the basis of length of service and, open quotation, not on any other fortuitous circumstance. There was an instruction of 1946, executive instruction of 1946, in terms of which the age of the candidate was a determining factor for seniority. Reliance is also placed on the observation para 34 of the said decision, where it is held that for determination of seniority of the officers, open quotation, who were recommended on the same date, age is the only valid and fair basis ... unquote. It is accordingly submitted that in the present case, since the appellant is older than respondent 1, he should rightfully get the second post of peon and would therefore be senior to respondent 1. Paragraph. Counsel for the respondent 1, on the other hand, placed reliance on the decisions in Bimalesh Tanwar. No, you say counsel to the respondent 1 first raised an objection on the question of maintainability of the present appeal, since it is against an order of a single judge in a writ petition challenging the order of the Education Tribunal. So it is pointed out that such writ petition could only be under Article 227 of the Constitution. And if that were so, no further appeal would lie. No other intra-court appeal would be maintainable. Reliance is placed on the decision in Ramesh Chandra Das versus Krishna Chandra Das, AR 2007 Orissa 146. So, on merits, Mr. Swine has placed reliance on the decisions in Chairman Puri Gramya Bank versus Anand Chandra Das, 1994 6 SCC 301, Suresh Chandra Jha versus State of Bihar, 2007 1 SCC 405, and Bimlesh Tanwar versus State of Haryana, 2003 5 SCC 604. Paragraph. The above submission considered. Paragraph. As regards the issue of maintainability, it does appear that there's doubt whether the present appeal would be maintainable. We'll stop in Ramesh Chandra Das versus Kishore Chandra Das, Supra. This court, after surveying the existing case law, came to the conclusion that such an appeal as the present one would not be maintainable before the division bench of the court. Full stop. It is pointed out that the subsequent full bench of this court in Mohammed Saud versus Dr. Major Sheikh Mahfouz, bracket 2008 2 OLR, bracket FB 725, has upheld this position. In particular, it is one of the conclusions reached is that, open quotation, no letters patent appeal shall lie against the judgment / order passed by a learned single judge in proceedings arising out of facts, unquote. Paragraph. Although the court is satisfied that the writ appeal is not maintainable in view of the legal position examined above, the appeal has nevertheless also been examined on merits. Paragraph. Here, the admitted position is that there was a selection committee which assessed the capabilities of the candidates, including Sri Kulamani Rao and the appellate number 1 hearing, and prepared a merit list giving individual marks to each of the candidates. Full stop. Since Kulamani Rao stood first in this merit list, with how many marks, sir? 47?
45.
No. Where do you get that? Because the 3 marks are given.
Yes, that I have
This
given at my
affidavit.
counter.
In this affidavit.
Counter. Well, Kudumani Rahul has secured 43.
40?
43.
With 43 marks.
And the respondent number 1, 41. And appellant 37.
Respondent number 1.
Respondent number 1, 41.
41 marks. And the appellant hearing got
Appellant
37 marks.
37.
37 marks. Paragraph. The admitted position is that Kulamani Rao was appointed against the first post of peon on the basis of his performance in this election by securing the highest marks in the merit list. Full stop. Interestingly, the appellant is not aggrieved by the selection of Kulamani Rao on the above basis. Paragraph. The next question that arises is, what is the rule that governs the question of seniority? Full stop. Here, it must be noted straight away that neither before the tribunal nor before the learned single judge was any particular rule cited that would govern the issue of seniority. Full stop. It is in this context that the affidavit filed by the appellant in the present appeal, relying on a GO dated 21st October 1982, is relevant. Full stop. Even if one would accept that the above circular / instructions of the government would apply where there is no specific rule, it is seen that in subpara Roman small 3, it is clarified. It is clarified as under. Let me take from computer page 418. Paragraph. It is therefore not as if, in terms of the said circular, the date of birth or age would be the criteria. Full stop. It is only where there is no such criteria that the other subparas of the circular would apply, and seniority will be determined, in case of two candidates joining the same date, on the basis of their respective dates of birth. Paragraph. The decision in DP Das Supra is not particularly helpful to the context. Full stop. There, the decision turned on a particular executive instruction of 1946. Full stop. Here, the circular referred to by the appellant is not helpful to the appellant, as even in terms thereof, it is not as if the date of birth will be the sole criteria. And it is only when there is no selection held will such criteria apply. Paragraph. If one were to proceed on the basis that there is in fact no rule specifying the basis on which seniority should be fixed, then the decision in Bimlesh Tanwar versus State of Haryana 2003 5 SEC 604 would become relevant. So there it was observed, relying on the decision in Chairman Puri Gramya Bank, Supra, as under. Just take A to A. Again, in Suresh Chandra Jha versus State of Bihar, Supra, the same principle was adopted. And after referring to the decision in Chairman Puri Gramya Bank, it was observed as under D to B. Paragraph. Therefore, even on the basis of there being no rule, it is plain that once a selection has taken place, it is merit which will govern the issue of seniority, inter se seniority of the candidate. Paragraph. The learned single judge was right in observing that with the first post of peon having been filled up on the basis of merit, since Kulamani Raul was high in the order of merit, top was the highest in the order of merit, and was accordingly appointed to that first post of peon. The question of changing the criteria when it came to appointment to the second and third posts of peon did not arise. Full stop. It must be noted here, full stop, the learned single judge rightly noted that if age were to be the criteria, then Kulamani, being the youngest, could not have possibly been appointed to the first post of peon. Paragraph. Interestingly, the appellant does not challenge the appointment of Kulamani Raul on the basis of merit. Full stop. It is therefore obvious that in this particular case, the appointments to the various posts was not on the basis of either the dates of birth or the lengths of service, but on the basis of merit in the selection that took place. Full stop. That was the criteria. The inter se seniority of the appellant and respondent 1 had to be fixed only on the basis of merit and not otherwise. Paragraph. For all of the aforementioned reasons, the court is unable to find any error having been committed by the learned single judge. The impugned judgment of the learned single judge accordingly calls for no interference. The appeal is dismissed. The interim order is vacated. No orders is to cause. In that, what about this contempt case? There's another writ appeal. What is all that?
Contempt, since your lordship disposed of the main case, well, contempt case is automatically disposed of.
And that second writ appeal, I don't know what that.
Second writ appeal, my lord, well, two writ appeals are there.
I see.
One
I think
against the
both
judgment of the
writ
State
appeals
Education
together.
Tribunal and one.
Yeah. And the
Against the
OJC and that
Yes.
FAO. Contempt case, you say in view of the dismissal of the aforementioned writ appeals 533 and 534 of 2016 by a separate judgment today. The present contempt case 167 of 2015 will now be listed with a single judge, master bench, on 4th January 2023.
I don't know 5 and 6 interruptions.
Disposed of his instructions, both 5 and 6.
I don't know 7.
You offer the respondent.
I am for the respondent.
None appears to the appellate. So not.
I don't read.
Garam.
I don't read.
None appears. Normal.
I don't 9.
9, my lords, I am for the respondent. The dispute has been settled, my lords. Amicably.
Counsel for the respondent informs the court that the dispute.
I'm for the appellant, my lord. I'm for the appellant, my lord.
Yeah, this is not disputed by counsel for the appellant. The appeal is accordingly disposed.
10.
My lords, item 10 is a audit assessment under the Entry Tax Act, my lords. The notice along with the AVR report was not served on us, my lords. So unless my lords kindly see, it is mandates, statute mandates that AVR report should be supplied along with the notice, my lords. 9C of the Entry Tax Act, my lords.
Mr. Vibra,
My lords.
this was not coming, this is not born on record. That is, before the tribunal, that was never the ground.
My lords,
Was it your ground? Where is your ground, sir?
my lords, competence of the assessment.
No. We are in STR review. We are not in writ. So whether you have taken this ground before the tribunal,
My
tribunal
lords,
had the occasion to examine this.
my lords, the competence of the assessment authority was taken, my lords. The last para, specifically this service of notice was not taken, but the competence of the assessment authority, acceptance and initiation of the proceeding was taken. My lords, I have taken the grounds in page 6.
Factually, what's the position?
B, para B.
Sorry, factually, what's the position?
Your Lordship, at page 9, here's page 9 of the tribunal's order. Running page 9. The grounds what my lord has pointed out. The grounds not before the
4C.
Your Lordship. 4C. 4C is the STO who has passed the order of assessment is not competent to pass the order. Under the provision of law, hence the order of assessment may be passed. That is not this ground, Your Lordship. That is.
What is the factual position, sir? Was it served on him or not?
Your Lordship, that I have to see the record.
All right. Counsel for the petitioner urges that the audit assessment is bad in law since the copy of the audit visit report was not served on the petitioner SSC. So, counsel for the department needs to examine the record to verify the factual position. Full stop. He will file an affidavit specific on this aspect, enclosing the relevant pages of the record before the next date. 11 January.
Item number 11.
My lords, item 11, this is under the Entry Tax Act, my lords. The sale, the petitioner is a manufacturer and the sale effected within the local area, my lords, should be excluded. Yes, assessing authority has not taken into account that, my lord.
What does the tribunal hold?
My lords, tribunal holds under section 20, I am liable to pay even if it is sold within the territory, the local area, my lords. Which is.
No, Lordship. Your Lordship, no evidence has been produced, Your Lordship, on the ground, on the point that these goods have been sold within the local area. No evidence has been.
No. That is not.
My lords, that was not the case in court below, my lords.
Correct.
Tribunal has not disputed that aspect is not disputed.
Your Lordship, only tribunal state admitted at page 11.
26, section 26,
Your
nothing
Lordship.
else. How will section 26 allow this?
Unless it goes outside the local area.
Local area.
Is there any fact finding that it has
No.
gone certain material
no,
after
Your
being
Lordship.
manufactured?
No,
They
Your
have gone
Yeah.
outside the
That
local area.
finding is
Yeah.
not.
Then it
All right. You say admit the following question of law is framed for consideration. C, I think C is.
Your Lordship, only the first appeal order, no proof has been produced. Any proof, Your Lordship, the page 18, Your
No, but
Lordship,
you should have questioned it.
Your Lordship.
Where's question of submitting proof? You not questioned it. Only question C in page 6. Whether under the facts and circumstances of the case, the tribunal was justified in confirming the order of levy of entry tax. Right? So entry tax
My lord.
on the entire sale, whether or not the goods were. What is this way you frame the question, sir? Just read how you frame question C.
See, my lords.
The tribunal was justified in confirming the order of levy of tax, entry tax, where goods were manufactured in one local area and sold within the local area. Question mark, paragraph. In the present case, the factual background is that the petitioner SSC manufactures PVC pipes using PVC resin as raw material. So, for the period 1st April 2005 to 31st December 2007, the sales tax officer, bracket STO, passed an assessment order on 2nd June 2008. Under Section 9, capital C of the Orissa Entry Tax Act, on the basis of an audit visit report, bracket AVR, which appeared to indicate that the petitioner had not paid entry tax on the sale of its finished product under Section 26 of the OET Act. Full stop. it is found that petitioner had sold scheduled goods to the tune of 73,50,466 inside the state of Odisha, on which ET at 1% had not been collected. So on this basis, the STO assessed the petitioner to tax for a sum of rupees 225,3, inclusive of penalty under section 9, capital C, bracket 5 of the OET Act. Paragraph. Before the first appellate authority, the petitioner contended that goods were sold within the local area, that is Cuttack municipal area, and therefore there was no occasion to collect entry tax. Full stop. However, the Deputy Commissioner of Sales Tax upheld the order of assessment of the STO. Full stop. Thereafter, the petitioner went before the Odisha Sales Tax Tribunal, Cuttack, bracket tribunal, bracket, with essay number 99, bracket ET, oblique 2012-13. Full stop. By the impugned order dated 31st December 2013, the tribunal dismissed the appeal on the basis of section 26 of the OET Act, relying on the judgment of this court in OJC number 13395/2000, bracket Messrs. Indian Metals and Ferroalloys 95, is it? Okay. 3395/2000, bracket Messrs. Indian Metals and Ferroalloys Corporation of Orissa versus State of Orissa, bracket. Paragraph. Section 26 of the OET Act just shows the OET Act. Section 26 of the OET Act only envisages collection of entry tax equal to the tax payable on the value of the finished products under section 3 of the Act from the buying dealer, either directly or through an intermediary. Open quotation, only if the scheduled goods are sold, if the scheduled goods sold are intended for entry into any local area of the state for the purposes of consumption, use or sale, unquote. Section 26 does not envisage the situation that is prevalent here, that is manufacture taking place in a local area and consumption within the local area. Consequently, section 26 of the OET Act can have no application in the circumstances of the present case. Paragraph. Counsel for the department then sought to contend that there is no documents produced to show that the SSC had in fact manufactured the goods in question in a local area, and it had also been sold within the same local area. Within the local area, full stop. This was not put in issue at all at any stage of the case before the STO or the DCST or even the tribunal. Full stop.
Before SCST, this.
What?
At page 18, Your Lordship, and in SCS page 18, I am of the opinion that the Law and Assessing Officer was very much right in its approach to levy the tax on manufactured goods sold in the local market in absence and any proof that such goods have actually been sold in the local area. in the result assessment made by the assessing authority.
But this was not insisted upon, sir.
Your Lordship, Learned First Appellate Authority has confirmed due to this reason, but tribunal has twisted the matter and not pointed out this.
Or this is not put in issue before the trial, you say. Paragraph. If it was the department was seeking to levy entry tax, then on the above basis, then the dealer ought to have been put on notice that he should produce proof that he had actually manufactured the goods in the local area. Stop. Consequently, the court is not in agreement with the conclusion reached by the tribunal in the present case. So the question framed is accordingly answered in favor of the SSC and against the department, petitioner SSC and against the department. The impugn order of the tribunal and the corresponding orders of the DCST and the STO are hereby set aside. The revision petition is allowed in the above terms, no order is course.
Item 12.
Let's item 12, page 13. I have
In
question
this
of law.
Copy is not.
My lords, here this is the exemption was upheld by the petitioner under the IPR, my lords. The certificate was not recalled, my lords, or modified. But after 2 years of availing the exemption, Director of Industries issued a letter that the exemption granted is not as per law. But by the time I availed the exemption, there was a valid exemption certificate, my lords. It cannot be retrospectively changed, my lords. That is the sole question for adjudication, my lords. The competent authority had granted the certificate, my lords. That is General Manager DIC, my lords.
The Director of Industries is retrospectively held.
Not
entitled.
Yes, ma'am.
It's binding sales tax authority. If your question
You mean to say director has given the eligibility certificate and the sales tax department is disputing that?
No, my lord. No. My lords,
the director himself said you're ineligible.
My lords, the general manager DIC.
That's what himself said that you're not eligible.
No, he has not stated, my lords. Another person, Director of Industries.
Whatever, sir. It is not the sales tax officer who's saying that you're not eligible. It is the director, DIC, which is saying you're not eligible.
My lords, how can it be retrospectively, my lords?
No, that has nothing to do with the sales tax authority. Have you challenged that in a writ petition separately? See, if the director DIC is now saying you're not eligible from a
No, my lords, sir, DIC is not telling, my lords. The competent authority under the statute, my lords, general manager DIC, District Industry
Sir, as long as the person refusing you the benefit is not the sales tax authority, the person refusing the benefit is not the sales tax authority.
My lords, what it was reassessed, my lords, on the basis, and one report was called for from Director of Industries. He is not the competent person, my lords.
Sir, you, according to you, some general manager is a competent person,
Yes,
correct?
Yes.
That general manager's decision to deny you the benefit, have you challenged that?
He has not denied till that, my lords.
That is the same department.
So how can it be same department?
Industries.
My lords, it was never recalled or withdrawn, my lords. The exemption certificate granted to me, my lord.
Okay. No, but there is an order of this general manager.
No, my lords, that is yes.
What has the director said, sir? He said you are not eligible, correct?
Yes, my lord. He says that the general manager who has granted the exemption certificate
Was wrongly granted.
Wrongly enhanced it, my lords. Capacity was enhanced.
My lords, kindly turn to page.
Sir, our case law is very clear. Whatever the DIC says is binding on the sales tax.
My lords, that is
If
what,
the DIC subsequently changes its mind,
my lords, it has not been changed. My lord. That is my specific case, my lord. It was never changed, my lords.
are there not two orders of the DIC?
No,
One by the
no, my lord.
one by the director, one by the general manager.
No, my lord. No, my lord. That is my case, my lords. Kindly.
No, what is it factually?
My lord,
You're yourself contradicting yourself. You just now said that the director said that the general manager wrongly granted you the.
My lords, kindly turn to page 13, my lords, my grounds.
No,
Question
first,
of law,
first
question of-
facts, sir. First facts. Let's be clear on facts.
Facts, my lords. It
Show us the two orders. First, the order granting you the benefit.
is 24, my lords.
Yes.
My lords, the last para, there is a column, my lords.
So, are you reading from the assessment order, appellate order?
It is appellate.
So, don't read from these orders. Show us the actual orders passed in the by the DIC.
That was not annexed, my lords, in this statement. Yeah. I'll file that along with the
The petitioner
affidavit.
wants to produce before the court the initial order passed by the DIC, granting him the benefit under the industrial policy resolution, as well as the subsequent order of the director, questioning the grant of such benefit. At his request, list on 5th January.
Let's say copy of the revision petition be served.
Yeah, right in the beginning, you say copy of the petition be served on counsel of the state. Right.
Thirteen.
This is a PI petition. The petition number 1 and 2 are the secretary of the SS group, and petition 3 to 4, 3 and 5 are the represent the villagers. Now the opposite party 4 to 5 along with some of the encroachers, they are encroaching the government land. They are not allowing the expansive road and also not prohibited to construction of the now the burial ground. For the present
Anyway,
petition,
representations, you say copy the petitioner's representations bracket annexure 4 series shall be examined by
Tahsildar
Tahsildar
opposite 4.
Kakatpur, and after notice to the petitioners and opposite parties 4 to 8, and after giving them a hearing, a reasoned order shall be passed thereon, not later than 1st March 2023. Copy of the order shall be made available to the parties within a week thereafter. The court clarifies it is not standing.
14.
May please, your lordship. This is in the nature of a public interest litigation, my lord. My lord, the petitioner number 1 is an advocate and the other petitioners are the villagers, my lord, inhabitants of the locality, my lord. Your lordship may kindly turn to annexure 1, my lord. The piece of the land measuring an area of 1.72 decimal, my lord.
Anyway, same
has been
representation, the petitioner's representation dated 9/11/2022. Should be examined by whom?
by the collector, my lord.
All right.
Collector Noyagad. And till then, let there
Not
be
even made
status
of
quo.
party, sir.
My lord.
Ocha, Collector Nayagar.
Yes, my lord.
Bracket opposite party number 3, and after notice to the petitioners and giving them a hearing, a reasoned order shall be passed not later than 1st March.
Here there is a separate department of Mission Shakti because the construction is by Mission Shakti, so they should also.
No, they are.
It's all your internal within your state.
Till then, my lord, let there be status
quo.
quo.
Made available within a week thereafter. The court clarifies it is not expressed anywhere.
Until a decision is taken, let there be a status quo in respect of the land in question. My lord, it is the property of the veterinary department, my lord. They are unnecessary, my lord. The Mission Shakti is, my lord, encroaching upon the land of the veterinary department and constructing. There is a veterinary hospital, and there has been, my lord, your lordship will find under annexure 2, my lord, a plan has been approved to upgrade the hospital, my lord. And in that particular place, now this Mission Shakti is going to construct. Till then, my lord, let there be no
The status quo at least, my lord.
All right.
My lord, otherwise, my lord, if they go on constructing,
15, my lord, I am.
my lord,
You're in 10.
Yes, 15.
or otherwise your lordship may say the collector will pass an
Call out now.
collector will pass an order, my lord.
I thought you said 10.
No. 15 and 16.
1-5.
1-5.
But this is a public interest litigation, my lord. Petitioner is a social worker, my lord. He has filed this public interest litigation for a removal of the unauthorized encroachment from the burial ground, my lord. Your lordship may kindly peruse to Annexure 3, page 50.
Anyway, the petitioner's representation shall be
Yes,
examined by
directed for inquiry. Tahsildar has directed for inquiry.
all. And after notice the petitioners and opposite parties
Inquiry
5 to 10 and giving them a hearing, a reasoned order shall be passed not later than 8th March. Copies been given to the parties within a week thereafter. The court clarifies not.
16.
In 16, my lord, this is also a public interest litigation. Here they have conducted the inquiry by the Annexure 2. They have stated that these persons have been encroached, but they have not taken any steps.
Annexure 3. So petitioners' representations, Annexure 3 shall be examined by the Tahsildar
on the basis of Annexure 2, my lord.
As well as opposite parties 5 to 10.
On the basis of Annexure 2, my lord, they have conducted the inquiry under Annexure 2.
Same thing.
17.
None appears dismissed.
18.
Worship, this is a case under the Odisha Municipal Corporation tax. So I am an advertising agency. I enter into a public-private partnership with the Odisha police to put up signals at 11 places in Bhubaneswar. And in return, I am allowed to put up small advertisements on those
Against these demands, there is no internal mechanism, no challenge permitted.
No,
the tax demand. How can it be? By a municipal corporation tax demand, there's no tribunal, nothing.
No, Your Lordship.
No appellate authority.
No
also.
appellate authority.
Can it be, sir? For every tax
I have examined the act, Your Lordship, yesterday.
People come to the writ petition.
Lordship,
is that the position? In all other states, Mr. Sahu, in all other states, if the municipal corporation issues a tax demand, it can be challenged either before a tribunal or an appellate authority.
Here, nothing, no remedy.
Everything writ petition in the High Court. For every small, somebody was asked even for 1,000 rupees tax, he will come to the High Court. This is too much. Well, how come they've not thought of creating some appellate authority for this? In fact,
here is for the year 13-14, they issue me a tax demand of 5,650,000. That's at page, Lordship will have it at page 28.
Anyway, there's no stay for the last 6 years. Have you paid the tax or not?
Lordship, I have deposited 5 lakh rupees. There is a stay operating.
Which is that order? I'm not able to find it. Which is that order, sir?
Oh, sure. That
no brief.
There's no. That order is not there.
See, we'll help you, sir. Just give him the paper book.
Lordship, I'm not challenging that there's no order.
No. See, when you come to your own case, when you don't know the orders, it's a pitiable situation. So we want to remedy that. Yeah, just show him the paper book. When I was a lawyer, if I got some order in my favor, I'll make sure it's with me. Here, no problem at all.
Lordship, there's no order.
Then have you paid the tax or not?
Lordship, I have deposited 5 lakh rupees.
Where?
Lordship will have that at page 32.
No. What's the total demand?
Total demand is 22 lakhs and not.
So there's no stay, sir.
Lordship, I'll just say one thing that it tripled from the previous year. And when I asked them that what is the...
So self-granted stay of tax. Say your municipal corporations are so generous, sir. Other municipal corporations, they will first thing they will make sure they get the tax. How will they run? How will they keep the streets clean?
Lordship, this
How will they have the lighting?
I am in a public-private partnership with the Odisha police. I am maintaining 11
So you're in a special category. Even if you owe them 16 lakhs, 6 years you don't have to pay.
Special category. I'm just saying that you give me the reasons on which you've tripled my tax for the same work. For the same work that I'm doing.
Look at you. You're such a privileged person. You don't have a stay order from the High Court, but since you're in public-private partnership, you don't have to pay tax.
Lordship, I'm in the best hands possible, Lordship.
No, you're in the best category. You're of your own.
Not at all.
Yeah, you've self-declared. I'm in public-private partnership. I don't have to pay tax.
I'm in a Lordship safe hands. That's all.
Safe is what? Registry is the safe hands. Not even, you don't need us also. As long as you find a petition, don't pay tax.
Lordship, I just want to know. I just asked them.
Sir, you are already in a very happy position. Why do you want to spoil that? See, now today we are going to ask you to deposit that 16 lakhs. See, you are invited trouble for yourself. So now, unless you show us receipt that you've paid that 16 lakhs, we will not even issue notice in this. So what do you want? Do you want to withdraw the writ petition or you want to pay 16 lakhs?
Lordship has put me between the devil and the deep.
Exactly.
Whatever, Lordship.
If your contemporaries in other cities know this, they will all demand that, scrap all the corporate laws. As long as we file writ petitions, we don't have to pay tax.
770,000 in that years, I think.
Lordship, they keep changing the amount of tax without giving me any information.
Subject to the petitioner paying the entire balance demand. Will you pay it in 4 weeks?
Lordship.
Within 4 weeks and producing before the
I'll not be able to. Lordship, I'll not be able to pay.
And producing before this court proof of payment. You say right in the beginning, for the last 6 years, there have been no stay of the impugned demand. Full stop. When questioned whether the petitioner has paid the demanded tax, counsel of the petitioner states that the petitioner has so far only deposited rupees 5 lakhs after the total demand of over rupees 22 lakhs. Where's the total demand figure, sir?
There is no figure, Lordship. That is the difficulty which I am. It's at, Lordship will find the impugned order at page 35. It's just one, they just give the number, that's all. No calculation, nothing.
No. What is that number?
21, 51, 620.
Of the total number, amount demand of rupees. No, 22.
22,
51.
620.
600 only.
6,000.
620. No. 620. Yeah, 620. Full stop. Paragraph. In the circumstances, subject to the petitioner depositing the entire balance amount within a period of 4 weeks and producing for the court proof of such payment. The court does not propose to entertain the writ petition. For the above purpose, list before the court on 2nd January.
A pleasure.
All right.
19.
In this case, the petitioner has challenged notice in form E24 by annexure 5 minutes. That's issued by the tax officer without complying rule 10 minutes and without granting any so-called notice in E22 and E23 minutes. Covered by judgment of your lordship in toy engineering, but E24 minutes, before I take your lordship's attention to order minutes, that's in E24, what is demanded is minutes, entry tax and minutes interest minutes. So I have taken partial instruction because full instruction has come. I was told that the entire tax in the meanwhile is paid minutes. And also minutes, the petitioner has paid some interest minutes, so I have to get the payment details minutes. And your lordship has kept all the interest matters to coming without 16th of December. So what?
Your lordship, here the matter has been sometime it is not within the knowledge. I think it is not within the knowledge of my lord and senior. Subsequent to this issuance of E24 as well as E8, your lordship, a detailed notice has been issued on dated 20th/6/2019. In that notice, it is another writ which has already been disposed of by this order. In that notice, your lordship, dated 20th June 2019, in respect a notice issued in Form E24 and E8 for the period 1 for 2010 to 30th for 2017, also impugned here. You have paid total amount of 0, nil, as against total tax due of rupees 36 crore, something. This is the notice has been issued, and pursuant to this notice, by challenging this notice, the petitioner has come to this honorable court by writ petition number 13,515, 2019. And in this writ, your lordship, the petitioner has filed undertaking. The board of manager, that is Sri Suresh Chandra Sharma is the chairman, has filed the undertaking, and pursuant to undertaking, your lordship, this honorable court has passed the order. Your lordship may kindly turn to the order. Operative portion is at page 2, paragraph 5. And your lordship, considering the facts and submission made above, the prayer made on behalf of the petitioner company is allowed. The petitioner company is directed to pay the outstanding of Odisha entity tax dues pertaining to 1 for 2010 to 30th for 2017, amounting to one show in 36 monthly installment. From 1st September 2019, the amount, if any, already paid by the petitioner company towards outstanding, so and so, your lordship. And your lordship, this order and also the notice, the impugned notice in that writ petition was pursuant to your lordship's direction in that batch of the writ petition that after 2017, after the judgment of Honorable Supreme Court, only interest has been levied. So far as the prior period, your lordship, that interest is pending. That interest we have not levied since the matter is sub judice before this honorable court. Now he is paying, your lordship. And so far as the merit of the case, your lordship, so far as the issuance of E24, your lordship, this is not covered by that Toyo engineering. Why, your lordship? For the reason, your lordship, in this case, in this bunch of cases, your lordship, on 3rd February 2010, Honorable Supreme Court has passed the interim order. Your lordship may kindly, that is a very peculiar interim order, Honorable Supreme Court. You have to admit, you have to admit the entire dues in your return, and you have to pay 1/3 of the entire outstanding, your lordship, in the return. So you have to disclose 100% in the return, and you have to pay 1/3 from the return. So what Toyo engineering said? Toyo engineering said, when you have filed a nil return and something which has been disputed by the assessing officer, then your lordship assessment has to be made. So here it is a peculiar case. E24, issuance of E24 is justified after disposal of the Honorable Supreme Court, your lordship.
So what my learned friend is trying to argue totally belongs to replace the judgment passed with Honorable Apex Court. Honorable Apex Court has never said that to incorporate all the transactions, even if we are para 30 of the judgment reliance case will out and pay the one. Honorable Apex Court said that whatever tax is payable, you pay 1/3, remaining 2/3 are remain state, and that will subject to the outcome of the SLQ for the Apex Court. Now, all the cases you also know the fate.
No, 1/3 is relatable to that para 30, that portion.
Exactly correct. Correct.
Not in entire.
No, these are the goods, correct. These are the goods belongs. These are relatable.
No, but Mr. Mishra, he's claiming he's paid the entire tax.
Entire tax have paid.
He's paid the entire tax, he says.
He's paying, your lordship.
I have paid, not paying.
Your lordship may kindly turn to this order. In this order, 36 installment has been granted, and what that 36 installment has not been completed.
Not been completed. No. 17. On 2017, it was completed.
So, your lordship.
How much has been? But he's claiming he's paid the full thing.
3 years. That means by 2020 you have completed.
No, 22.
No,
This is the
19.
order.
This order has been passed in 19.
Yeah, but we are in 22.
Your lordship.
It must be over by now.
Your lordship must have been paid.
Let me come up with all details, man. What I am praying, Vilas. Let me come up with all material.
So what my submission? This
Let him file a supplementary affidavit.
Correct.
All right.
Yes.
Mr. Sahul and senior counsel for the petitioner states that he will file a supplementary affidavit, that the petitioner will file a supplementary affidavit to indicate the payment of tax pursuant to the order passed by this court on 18th December 2019 in writ petition civil 13515/2019, which was the petitioner's own case.
So also the other matter also, I will file out.
Which is the other matter?
19 and 20.
Same order in 20 also.
Fine.
List on. First March. 21st March.
Lordship, I'm sorry, I'm disturbing. Item number 18, I'll withdraw the writ petition. I'm sorry. I'll pursue my remedy.
It has taken for 10 minutes for you to register.
I'm really
that.
sorry.
All right. Counsel for the petitioner seeks leave to withdraw this writ petition
And pursue my remedy.
with liberty to pursue other remedies as may be available to petitioner according to law. This poster is withdrawn with liberty is prayed for.
Deeply obliged.
All right.
Item 21.
My lord, item 21, just I am received the counter from my learned brothers.
All right. Rejoinder be filed for the next date. This is 2017 matter, sir. What is the matter about? Why do you need rejoinder?
The ITT has already been passed order. They have not implemented that appeal effect order. So before this court, my lord, meanwhile they file a counter giving us wrong calculation. So I take instruction from my client whether the calculation is correct or not. So 7 days time can be granted. So because it is a survey matter, during survey has paid some amount that has not taken care of while computing
But this is like an implementation of the ITAT's order.
My lord.
It will become like an execution petition.
Already.
In the ITT procedure, there is no power of the ITT to implement its own order.
So High Court becomes executing court. ITAT.
No content power of ITT.
Anyway, this is rejoinder is be filed for the next date. List on 28th March. 27th March. 27th March.
22.
The petitioner has rights or file a substitution petition. So that may be allowed.
Date charts.
No, that is 18117 at flag.
Oh. In the IA you have filed, is it?
Yeah, I have filed.
Oh, I see. All right. Close the camera.
So kindly have a glance to order number 4, that is 5/2/2018. So here issue has been settled and they have to file the counter. So last 6 years the counter has not till filed.
Let's see. Your Lordship, I may be permitted to file counter. Let's see, this is the assessment order.
All right, it's a last opportunity to file a reply within
Now,
4 weeks.
My lord, this is also covered by my lord orders recent. That's the opinion has been not formed in the file initiating the.
So all the more he has to file a reply, sir. Last option to file a reply within 8 weeks, rejoined for the next date. It's made clear there will be no further time granted for that purpose.
So interim order to be
interim order to continue 28th March.
Grateful, Your Lordship.
23.
This is like that petitioner is a manufacturer and also doing the mining and also distribution generation of power. So they are entitled to purchase the goods against considered against C farm under section 8(3)(b) of the CST Act. So after implementation of GST, the government of Orissa issued a circular and just that is 17/8/2017, that annexure 7, page 120. And that withdraw the concession rate of tax. So challenging that order, the petitioner filed a writ petition that is in annexure 3, page 41. And here the order has been passed.
12th December.
12th December. And directed, and in the meantime, the state government also withdraw the circular and come up with a circular and allow to issue the CFA. And subsequently, all the, and it is directed, kindly have a glance to that page 46 of that order. That is the Carpo Power Limited for the state of Haryana they have cited. And this has been, in that event, the petitioner having had paid the oil company the amount on account of first respondent wrongful refusal to issue CFA, the petitioner will be entitled to refund and adjustment of the same from the concerned authority who collected the excess tax through the oil companies or otherwise. The concerned authority shall process such a claim within 12 weeks of the same being made by the petitioner writing and petitioner furnishing the required documents. And here we have got a manufacturing unit as well as mining and also general. But subsequently, what happened, the HPCL, the Government of India undertaking, did not allow us the purchase against CFA against the manufacturing. But we are entitled to, and prior to that, they were allowing us. But kindly have a glance to.
Anyway, they were not even, notice is not even gone. It's a notice. It's accepted on behalf of 2 and 3.
And Your Lordship.
The state of West Bengal also you have to serve.
Your Lordship, all the entire prayer is against opposite party now 5 to 9. All are West Bengal.
No. You see, state of Orissa, Mr. I. Mohanty. I. Mohanty.
2, 3 is on Mr.
Christian.
2, 3, 4, Mr. Mishra. Now 5, there's on Union of India also.
Well,
4, say Mr. Paddy. And then 5 to 9. Notice returnable. 28th March. The tracking report will be placed in record.
24.
Item number 24, Your Lordship, of Mrs. Pamirat. Lordship, she is unwell.
All right.
I pray for one adjournment.
All right. Counsel for the petitioner is stated to be unwell. List on.
Lordship, 19th, week commencing 19th December.
What's the urgency? This is that 2021 matter.
Oh, okay. Your Lordship, as Your Lordship wishes.
5th April. Right.
Obliged, Lord.
25.
May I please, my lord? Here I have challenged the Annexure 1, the show cause issued by the state GST authority. Since the matter is now pending before the central GST authority, and as per Annexure 4, the Panchanama and everything was and already seized the documents by the central GST authority and pending. So in the meantime, the state GST authority issued notice to the last chance.
After getting the compliance, after getting the submission that these are pending before central authority, Your Lordship, we have issued, Your Lordship, this letter. We have issued to the central authority this letter. Your Lordship, all these notices are of 2018 and 19. Your Lordship, we have issued the letter to the central authority. Till that, we are awaiting. We are not taking any action. We are awaiting the range of Your Lordship. This is a state jurisdiction. The dealer is under state jurisdiction. So we have intimated that what action you have taken. So no response has been. Just now we have issued reminder to the central authority. So let it be there, Your Lordship. We will not take action
I'll take it
till getting any compliance from the central authority.
But we'll record a statement.
Or Your Lordship may direct the central authority to dispose of in a time-bound manner.
No, let whatever letter you have given, that let me take.
That is the letter that we have
take instruction on that issue.
As per Annexure 5, if the central agency has initiated the proceeding, they have to complete as they are a letter, my lord.
Lordship, keep it. I'll take instruction.
Mr. Mishra, learned counsel appearing for the state, has produced a copy of a letter dated 20th February 2020, written by the CT and GST Circle, Rourkela 1, Udit Nagar, to the Senior Intelligence Officer, DG of GST, I. Asking for requesting for sharing of the purchase invoice, sales invoices, and other related documents involving the petitioner. As well as the progress investigation. First off, he states that awaiting the reply of the DG, GSTI, no further steps are being taken by the state authority. Paragraph, Mr. T.K. Satpathy, Learned Counsel appearing for the GSTI.
OP3.
Bracket OP number 3, seeks time for instructions. 28th March.
No courtship action.
Your Lordship, recently, your Lordship.
Already said, recorded statement, they are not taking any steps.
Your Lordship, recently your Lordship came into experience that what they have stopped and we have started. Again, we have started. So this is going over. So this is only a jurisdiction issue, your Lordship.
26 and 27 same, my lord.
Same, your Lordship.
Same order in 26.
28.
May I please, Lordship?
Yes.
Lordship, in this matter, already discharge certificate has been issued by the investigating agency unit, but after that, attachment has been made by the state authority. Under connected matter, challenging the audit notice from the state authority after issuance of discharge certificate is also pending before your Lordships. And I'll take your Lordships to the decision of your Lordships in.
No, it's coming up for the first time.
Your Lordship,
This is for the first time.
Answer 3 is the attachment notice. Without enclosing any order, this attachment notice has been challenged, your Lordship. Your Lordship, only the central authority discharge certificate as well as this attachment notice. So let the petitioner submit, enclose all the copies of the pursuant to which this attachment has been done.
Your Lordships, kindly have a glance at page 14. The entire issue starts with the scrutiny, where discrepancy for the period 2017 and 18. Next, second paragraph, your Lordships. Furthermore, from annual GST return GSTR 9 and month 5 GSTR 3B for the period 2017-18 and financial year 2018-19, it is evident that there is reversal of ineligible excess ITC amounting to such and such amount without payment of applicable interest. So after scrutiny, they have found that only grievance for the 2017-18 period is regarding interest. And next page, in the next page, in the discharge certificate, para 3, your Lordships, on the scrutiny of documents pertaining to service tax coupled with recorded statement of Paradip Parivahan Limited on 18/9/2022, it was revealed that RCC had sought paid service tax amount to such and such in April to June 2017 quarter. The RCC was asked to discharge such liability along with applicable interest and penalty. The RCC discharged the same, void such and such order dated 28/9/2020. So already everything has been paid. And their attachment is for the period 2018 and 19. From 2017 to 19.
No, I think his point is all the orders on the basis of which the demand has been raised.
Yes, Lordship.
You have not enclosed it to the writ petition. He says.
My humble submission before your Lordship is that when audit is still pending and challenging the audit notice, I have before your Lordships. And that writ petition is also pending before Lordships.
When is that coming?
This petition is.
Is there any interim order in that?
No, your Lordships.
Okay.
That is only 22239 of 2022.
22. When is it coming up?
So it was there before Lordships, and for the removal of defects, I was allowed for 2 weeks time, and I have already removed the defects.
So let's both come together. List along with
22239 of 2022.
Sorry, 222? 39
of 2022.
2022 on. You'll have it in January. Because this demand is what? Date of the demand is what?
Your Lordship, that is my
1710.
respectful submission. At page 11, the prayer, he prays to quash Annexure 3. Annexure 3 is the attachment notice. And attachment notice must have been followed by
the
assessment order.
Without
Either 73
determination.
or 74 or 63.
Your
That
Lordship,
has not been enclosed here.
Your Lordship, when audit is pending, how the final order they have passed? Audit is pending.
No, but have they passed or
No.
not passed? That you find out.
Yes,
So,
yes,
like
yes.
the other day, suddenly you shouldn't produce the order and say that it's already there.
Now, in that case also, my learned friend also will agree on that. In a belated stage, after filing of the writ petition, they have given me that order.
Maybe
And
now
that
you'll
is why-
trigger. Now you'll trigger this.
No, that is why I have filed the additional affidavit also.
Yeah, 8th December.
The Lordship, I am appearing for
Your Lordship,
opposite
Your
party
Lordship,
number
on
1.
Your Lordship, on that week, 6 to 8, I will not be here.
Oh, you're not here. 15 December.
Your Lordship.
The Lordship, I am appearing for opposite party number 1. A copy may be served to us.
29.
May I please, Your Lordship. We are challenging the proceeding of final order under section 73 of the GST Act and connected matter, Your Lordship permitted to file appeal and with a condolence with that order.
All right, same on.
Your Lordship, date may be only changed. 14 December.
Oh, the order is not there, sir.
This is all. I'm giving 2 sets of
Not later than 19th December.
Obliged.
All right. Same on.
Obliged.
Your Lordship, here, just I may be permitted to point out, Your Lordship. Your Lordship, here the order has been passed in January. Your Lordship, there is outer limit so far as the 107 is concerned, Your Lordship, to file the appeal within a period of 3 months, Your Lordship. Your Lordship, and the writ petition also filed in the November, Your Lordship. So, enter limited.
The one, you mean Mr. Naik's matter?
Your Lordship.
The attachment order is December, November 2020. Your Lordship can have the consequential.
Let me.
That's then Your Lordship. Then then opportunity. Then you will go to the principle of natural justice. 3 opportunity of hearing to be granted. Your Lordship had that time. Your Lordship permitted to file.
Annexure 1, the order under section 73, Your Lordship. This order, page 14, has been passed on 31st January 2022, Your Lordship. It is appealable under section 107, Your Lordship. As per section 107, this appeal is to be filed within a period of 3 months and outer limit is there, Your Lordship. And without filing appeal, he has challenged here by filing a writ petition. Even though, Your Lordship, within that limitation period, this writ petition has not been filed. This writ petition has been filed after lapse of the limitation period in the month of November, Your Lordship. This writ petition has been filed.
So if it is barred by limitation, that the authority will take care
Your
of it.
Lordship, page 53, Your Lordship. The order, consequential of the order, attachment order, Your Lordship, kindly page 53, Your Lordship.
Anyway, that authority will decide if it's time barred.
Your Lordship. Obliged.
At number 30.
May I please, Your Lordship. Here I have
No counter filed.
My Lord, similar writ petitions are already disposed of.
Ah.
Batch of writ petitions.
Same.
Batch of
this is
they
Counter filed. Maybe.
in your side.
Transport fee, same thing. That
same.
Same one.
31.
31 is also permitted to withdraw with liberty to file afresh if any cause of action survives.
All right. Concept the petitioner seeks leave to withdraw the present petition with liberty to file a fresh petition if any cause of action survives. This post of is drawn with liberty is prayed for.
32.
My Lord's permission to withdraw with liberty.
All right. Same order.
Obliged.
33.
License in question was operated over a leasehold piece of property, my lord. And after 31st of August, my lord, which was valid from 1st of November 2006 till 31st of October 2018,
The landlord thereafter did not agree to continue with this on-shop. And as a result thereof, the license could not be renewed. The Just Your Lordship sees page 27. Page 27, Lord, the excise authorities have passed orders that the license renewed till 31st of August 2021. Page 27, Lordship sees 118%. 21, subject to shifting of the shop to the other side. Gets it, man. Now, after this, before that, in fact, I had applied for shifting. Shifting took some time. There's inter-se communication. And now, finally, my appeal was allowed by the commissioner that I will be allowed to shift it. That order I have filed. But after the appeal was allowed, Lordship sees I am really agreed by Annexure 1, page 13. Kindly see that. But the only to this extent I am agreed. But the Superintendent of Excise has directed me that I'll be allowed to shift subject to deposit of up-to-date license fee. I have only just one small point, my lord. From 31 August 2021 till date, my license has not been renewed, nor I am having any license. For this period, my lord, I will not be liable to pay this license fee because I am not having license, and all the license fee only on account of having a license. Now, if your lordship could kindly consider the T.R. Balu's case, when the license on-shop and off-shops remain closed on account of Honorable Supreme Court's judgment, the government for the closure period has already exempted all those shops. Because the licenses were not there, shops remain closed on account of T.R. Balu's judgment, my lord. Here also, some other difficulties may be different, but shop remain closed, licenses were issued. Now, for that simple reason, the Superintendent of Excise should not have directed me to deposit the entire closure period license fee. To that extent only, I am before your lordship, my lord. Now,
no, but we are asking the Secretary Revenue to examine many of these cases.
Your lordship,
we are asking the Secretary Revenue to examine many of these cases, I think.
Here
compensation for, the waiver due to closure.
Correct. Those are the cases, my lord, where either licenses are not there, shops remaining closed. Here my...
No. Where licenses were there, but they were unable to operate for various reasons.
But here, my shifting has been allowed. I am to open my shop. I have already invested. I am just to open the shop. Lord, may I just request your lordship? In fact, after this closure, already 4 or 5 months I have already paid to the government, that the government will take a decision with regard to adjustment, refund, whatever it is. But
may I suggest one thing, subject to my learned friends? Let the commissioner be directed to renew the license and subject to adjudication with regard to his liability of payment of license fee, impugned demand. Let the license, if the commissioner will take a decision, because commissioner is the appellate authority, he will take a decision that so his renewal should not stand on the way of deposit of this impugned license fee. That part should be directed, the commissioner should be directed to adjudicate by way of an appeal, and he should continue his shop by paying the current license fees.
That will do.
All right. The challenge in the present petition is to an communication dated 6th August 2022 of the Superintendent of Excise Bhubaneswar to the petitioner, requiring him to inter alia show proof of deposit of up-to-date license fee for the purposes of permitting the petitioner to operate from a new site as regards the IMFL on-shop for the balance period of 2022-23. Paragraph. Having heard learned counsel for the parties, the court directs that subject to the petitioner depositing the current license fee.
Current license.
Yes.
The petitioner will be permitted to operate from the new site.
New site.
Yeah.
Yes.
New site for the remaining period of 2022-23. And
so far as the impugned demand is concerned, we will file appeal. So far as the impugned demand is concerned,
will be permitted to question the impugned demand before the commissioner by way of a appeal, is it?
Yes, my lord, by filing appeal.
Appeal. It shall be filed not later than 19 December 2022. Such appeal, if filed within that date, That will be decided with the commissioner after hearing the petitioner by reasoned order.
Yes.
Within a period of 2 months thereafter.
Obliged.
That will do.
Till such time, no coercive steps will be taken against the petitioner as far as the demand
is concerned. Impugned
demand is concerned. Right. The petition is disposed of.
For orders. Add-on 34.
May I please your lordship? This review petition has been filed by the Union of India, challenging the order dated 16/9/2013 by the Annex 1, my lord, arising out of WPC number 19737 of 2013.
What's the delay, madam?
Today, my lord, delay is the period of delay is 126 days, my lord, for filing this review petition. Delay of
495 days.
126 days, my lord.
495 days.
Oh, my lord. That's the miscase number 32 of 2014.
There's an inordinate, extraordinary delay of 495 days. 495 days.
495.
In filing the review petition, which has not been properly explained. Consequently, IA number 32 of 2014 is dismissed. As a result, review petition is dismissed.
35.
Well, delay is 126 days, my lord.
Our calculation is 490.
126 days, my lord, wrongly calculated, that is there.
No. Yes.
Okay, withdraw, my lord.
Council petition seeks leave to withdraw this petition. Dismisses withdraw.
36.
36 million pass over.
All right.
37.
May it please your lordship, my lord.
Yes.
My lords, oh, my lords. Yeah, my lords. 31988 diuntu. Xerox ithila. Diuntu. My lords, here the books of accounts having not been rejected. Now the estimate has been made. Oh, my lords, you will kindly see the order of the tribunal at page 32, my lords. Order of the tribunal, my lords. Para number 5, my lords.
Considering
the closing stock of goods as per stock account maintained, transfer of goods from against Form F, the balance goods available for sale is worked out at rupees so and so, but the sale price when compared is found to be at a rate, which includes the sale made to registered dealers. So the sale is less by 36,33,262. This discrepancy could not be satisfactorily explained by the appellant. The finding of the lower forum is based on a report submitted by the Circle IST and verification of books of accounts, stock receipt, invoice in respect of aerial powder where the sale price is found to be rupees so and so by sale number. So here, the learned STO has arrived at the point that landing cost of the goods as also the sale value excluding tax. It is also examined by the first appellate authority who has categorically observed the power of patent holder, has admitted the goods. So, and the learned SCST has verified the stock receipt. Thus, you will kindly see the order of the STO. That is at page 10, my lords. I'll read the the relevant page is at page 12. As against the claim of sales to registered dealer of rupees so and so, the dealer company furnished the required declaration form for rupees 1,25,40,539,
but on scrutiny of the said forms, it is found that transaction covering more than one quarter has been reflected in following number of D forms, in contravention of the provisions contained in proviso to Rule 27.2 of the OST rules. So the amount reflected in the said the 8 number of declaration form.
Anyway, you just say notice. You accept
Yes.
notice. Notice is gone in this.
Yes. I would have thought. Basudev.
6th April.
It has 37.
What about 38?
38 is to be dismissed.
Okay.
With that
Steps
is
for
a
limitation
delay.
were not taken and defects have also not been removed.
It is a good case. But that is delay could not be, he has not given any certificate. So I said, you give me my money and you go to
dismissed on the
oblige my lords.
39.
No instruction. No instruction. Memo taken on record dismissed on account of no instructions.
40.
My lord, item 40 to 44, the order has already been complied, so it can be dispersed later. I'm filing the memo, my lord.
All right.
Oblige, my lord.
It stated that the order under review has already been complied with. These petitions are disposed of. The memo is taken on record, disposed of as infructuous.
Withdrawn, my lord.
Withdrawn, disposed of.
Oblige.
45.
None appeals dismissed.
46.
Same order.
47.
None appeals dismissed.
48.
48, my lord, I will remove the defect within a week, my lord.
So it's a 2017 matter, deficit code fee 88 not paid.
Within a week, I will remove the defect. 3 days, your lordship may call it on Monday. This week, I will remove the defect.
Okay, as a last chance, defects be removed within a week list thereafter. All right. Same for 50.
49.
Yeah, all same.
Till 72.
Huh?
Till 52, my lord.
52 copies have not been solved, your lordship.
Yeah, all defects be cured. It's part of that. What is there in the matter, sir?
CST has been paid, my lord. Interstate transaction, my lord. CST has been collected in the state of Maharashtra. Now, Odisha is demanding.
All right. All right. Defects be cured within a week list thereafter. Right.
53.
Your lordship. Lordship, here, the question of law is at page 18, your lordship. Whether in the facts and circumstances of the case, the Law in Odisha Sales Tax Tribunal is justified in treating quantity discount and special cash discount as state discount.
I thought this is covered.
Your lordship, cash discount.
This is not discovered by.
No, your lordship.
I think so. It's covered. I want to examine it. I think I remember. No.
Section 2, it's. Your lordship, let it be.
All right.
No, it is not purchase sale price. Section 2H. Section 2H, the cash discount.
Yes, so we've decided that point.
Your lordship,
You already decided in 2 or 3 cases. My case also decided. Citing judgment of C8 and from the Supreme Court judgment has already decided.
Yeah, just share it with us.
Yes.
I'm sorry. Your lordship.
Yeah.
Yeah,
Okay.
there is a case of mine also in 60. Today list also there. Today also there is a case, not item. My case also, not item. Old item, not 40. Tax return there.
Let's see, let it be and next week or
at the request of
1 week
Mr.
after. Next week.
List on 1st December.
Your lordship.
Not 1st December. 1 minute. 1st December is this week itself. Okay, we'll pass it over. He has the order. All right, pass over.
54.
Your Lordship. Item 54, Your Lordship also has decided these cases, Your Lordship. May kindly turn to page 16. The 42.5 penalty under section 42.5. No discretion in that Chandrakant Jayantilal case, Your Lordship has already decided. Once assessment has been completed, Your Lordship, penalty is automatic. 2 times penalty is automatic. So far as 42.5 penalty is concerned. And
So
Your
now
Lordship,
we have issue notice in this then. It's before notice. All right. Counsel for the state informs the court that the point urged by the state is covered in its favor by the judgment dated 5th July 2022 in STREV 69 of 2012, bracket State of Orissa versus Messrs. Chandrakanta Jayantilal. Notice returnable. 3rd April.
55.
None appears dismissed.
56.
56 is the same as 54, Your Lordship.
Or same order as 54. Right.
57.
57, Your Lordship. Your Lordship, paltry amount, it is if
the tax amount being
both the amount will be considered.
Court does not propose to interfere. Leaving the question of law open, the petition is disposed.
58. 59.
Same order.
60.
None appears dismissed.
60. There's a withdrawal memo.
The memo is taken on record. Dismiss is withdrawn. All right.
61.
61, my lord. I am permitted to in online mode. 1 week time may be granted to correct the defect. Annexes is not.
This matter has become infructuous because the ECs have been challenged before the NGT Calcutta High Appeal number.
My lord, there are various factors we have challenged in this PI.
Main factor is
EC is there. That prayer I will not be pursuing. But there is
already challenged before the NGT.
Land acquisition. We are also challenging the land acquisition when the FRA applications are already pending. That is also there.
No, so far as your Lordship may remember, your Lordship has sent us for a public hearing, and these are all related to EC. Land action matter is not. Otherwise, it cannot be a PIL. PIL they have filed on the ground that there is no environment clearance. EC has already been granted. They have challenged it before the NGT, and I have given the numbers of that NGT appeal number. So that is why the parallel proceeding cannot run. If
there are several players. One of the players that is pending is regarding settlement of forest right and land acquisition.
Those are also to be, so far as forest land is concerned, any EC granted, that is also.
That can be decided in the tribunal, my lord. Relating to land acquisition, when the FRA application is pending, that cannot be decided in the tribunal.
Why don't you withdraw this repetition and file a separate? Because every time you're taking adjournment for amendment, you withdraw, file a fresh petition, sir.
Then one week time, I will file the.
Already granted 2 adjournments, sir, for this.
Last chance, I will file the amendment, and my lord may hear it.
No, you withdraw this and file a fresh petition. So, counsel, the petitioner seeks to withdraw this petition. Petition in accordance with law, limiting with appropriate prayers, right, in view of the subsequent developments. Disposed of is withdrawn with liberties prayed for.
Obliged.
Right. Lord, I may pardon, Lord. Item 58 and 59, Lord. Mr. Potti has expired, Lord. Brief is allotted to me.
All right. 58 and 59 at the request of Mr. Satpathy, who states that he will file his wakalatnama for the petitioners.
Defect, I'll remove the defect.
And remove the defects within a week. List after removal of defects.
58 and 59.
Right.
Oh, bless me.
62.
Lord, I will remove the defect within a week, Your Lordship.
Defects will be removed in a week. List thereafter.
63.
63. 63 is a matter, the petitioners are the parents of the students of. I'm sorry.
Defects have to be removed, sir. Defect be removed.
Vakkalatnama, the name is not right written in.
No, there are two defects.
7.1 and 7.2, madam.
No, 11.
Okay, okay, madam. I'll remove the defect. Madam.
Defects be removed within a week. List thereafter.
Okay.
64. My lord, on behalf of Mr. Arvind Mahanti, may kindly take in as next week.
All right, defects be removed. List thereafter. Right.
65.
65 may please. It's a case, my lord, of the appointment of local people under Odisha Adarsh Vidyalaya situated at Balrampur village. I have gave the representation which is annexed in Annex 2 that is pending before the Office Number 2 collector. That the said Annex
These are all service matters, sir.
This is a PIL matter, my lord.
No. How this is for engagement of petitioners, villagers.
No,
in accordance with their qualifications, this is all service matters.
Earlier that my honorable lordship has directed that to give a government land to establish a model school. That has been.
The prayers are for engagement of the villagers in the school. That's the prayer. For engaging people as villagers in the school and all, this is not PIL, sir. Answer to the petitioner seeks leave to withdraw this petition with liberty to seek appropriate remedies in accordance with law. This post office withdrawal liberty is
straightforward. 66.
My lord, 66 and 67. Order of assessment has been challenged and filed the appeal.
All right. Counsel to the petitioner seeks leave to withdraw these petitions with liberty to file an appeal as provided in law. If the appeal is filed not later than 2nd January 2023, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of the present petitions, it will be examined in accordance with law by the appellate authority. The originals of the annexures be returned, subject to being substituted with attested photocopies thereof. This post office withdrawn with liberty straight for in the above terms.
68.
68, my lord, 1 week time to remove the defects.
All right, defects we removed within a week.
69.
May it please your lordships. My lords, by making a contradictory stand at page 9, lords will find that is Annexure 1, a notice under section 148A, small b was issued. How it is contradicted, lords will. As per information available in the inside portal of the department, you have credits to each bank account. The subject were summed up financially revised and tallied with the income shown in the ITRs. It is found that you have disclosed income of rupees 18,89,665 during the financial year 17-18. However, it is seen that you may see this also. However, it is seen that no return of income is filed by you for the relevant assessment. Then he issues a notice. Thereafter, my lords, I give a reply. Lords will please to see at Annexure 2. Then, Annexure 3 comes the outcome of my reply. And the outcome of reply is also very interesting. I'll just take your losses to the last page of that order, page 15, the middle one. However, the documents needs verification. Without verification of documents, it cannot be concluded that there is no escapement of income. So admittedly, he has made, so far as 148AC, totally OTOs. 148AC says that the assessing officer has to consider the explanation and other documents. And thereafter, on the Annexure D, he will pass the order. I think your lordship is feeling uneasy.
Just come to 148AD.
Yes.
It's a decision.
Yes.
Income Tax Act.
IT Act.
He has considered your reply, he's given a decision.
He has that decision, my lords, is based on no verification.
No, whatever. Again, we're back to Punjab and Haryana.
No.
Yes.
My lords, this time the revenue is going to be totally annihilated. Totally annihilated. I will prove. If your lordship is not comfortable now.
No, very comfortable.
Yes. I'll show, my lords.
Yes.
If your lordship may kindly allow me to place 148 AC.
Yes.
C says, consider the reply of the assessee.
Correct.
Furnished, if any, in response to the so-called notice referred to in clause B. If he says
that all provisos to the Supreme Court order in Punjab and Haryana has to be done only with the Supreme Court. We can't add provisos.
No, my lords. I am not. Punjab and Haryana, with great respect, my lords, cannot be treated as a precedent for all the cases.
No, because it's proved by the Supreme Court, not by a one.
No. Supreme Court, my lords, the facts has been decided what? That in Punjab, Haryana, Anshul Jain's case, the assessee came before the High Court. He was given opportunity. That has been explained also by the division bench of the Calcutta High Court and also by a division bench of the Delhi High Court. That decision is also with me. Okay, I think
since you're not making headway, you want to get out.
No.
See, when you asked for listing of this matter,
yes.
I told you it should come with the other batch. You said no, it should come on Monday. Then I told you, if you do that, Mr. Karan, all of them will be unhappy. It's because I would have given a big judgment today, and on Wednesday there will be nothing left to argue.
No, my lords. I have got all the results. I'll meet. Lordship will see. If he has considered it, then why did he say the documents?
Then we get into the merits. See, the point is, the minute we enter into this territory, we have to start discussing the 148A(D) order. We have to necessarily examine it on merits in a writ.
No.
Naturally, without discussing this order on merits, we cannot interfere with it.
My lords, no, it's still 5 minutes left. 3 minutes. 3 minutes left.
See, the danger is I'll be more energetic after lunch.
Yes.
No, that's a danger for you.
Very dangerous. Very dangerous, my lords. Hats off your lordship's memory. Lordship remembered on the day when I mentioned the matter.
So after lunch, we cut.
After lunch.
You had your lunch or you did not?
I
All right.
I don't know. 69.
My lords, I was just before lunch, I was submitting before lordship that Anshul Jain cannot be said to be a precedent. Why I am saying so, my lords? Lordship will kindly notice Anshul Jain case. Kindly notice the facts of that case.
All right. Let's see that.
Yes. In that case, what happened? A notice was issued under section 148AB, so-called.
Correct.
He filed a reply. The AO rejected it.
Ask him to correct it.
Beg your pardon, ma'am. Olikota mila. I'll get tired.
So same. Counsel for the petitioner contends that the impugned order is erroneous.
No, my lords. Before that, may I take your lordships to the beginning?
Yes.
the petitioner is an assessee under the Act,
Right.
full stop.
Right.
As per the petitioner, he filed his return for the assessment of 1819, which was duly assessed by the order dated 26/3/21. Here we understand that it is a scrutiny assessment. Okay. On 14th of March 2022, he was served with a notice under section 148 small b of the Act, claiming escapement of income chargeable to tax for the assessment year 1819. Along with the notice, the petitioner was supplied with information forming basis of notice under section 148b. The petitioner responded to the same by communication dated 21/3/2022, which stand rejected by impugned order 31st of March 2022. Counsel for the petitioner contends that the impugned order is erroneous, as the same has been passed without considering the objection raised by the petitioner. Here I will pause you, Lordship, for a moment. We have not seen the order of the Honorable High Court of Punjab Haryana has not quoted so far as the 148A-D order, which was challenged before that.
We will also not quote it. We can tell you that we will also not quote it.
Now, my lords, the present case, we do not know, my lords, what was the order there. It is said that he has rejected it. Here the order says that I have, unless I go to the materials entirely, I cannot conclude that whether there has been escapement of income or not. Now your lordship will see the 148A, then B, then C, and also D. B is the first he has to conduct an inquiry. B is he has to issue a show cause. And C is he will consider the reply. And D is he will pass an order. That is the... Now, my lords, before this act came into force, my lords will agree that there was no such provision or safeguards for the assessee.
Except GK and Drive.
Except GK and Drive. That judgment also, which came much after the amendment with effect from 1/4/89, only said, my lords have got some problem.
No, nothing.
But that also came much after 1/4/89. Then, my lords, what happened there? The court said, my lords, that whenever a reopening is made, you file your return, then also you file an objection. The assessing officer first will treat the objection. Then, after the objection is disposed of, he will proceed to assess. Proceed with the assessment, reassessment. Now, my lords, all these things now has been strengthened by the act which came into force with effect from 1/4/2021. My lords will agree with this. Now, previously only two exceptions were there. That is the first proviso to 147. No assessment after 4 years will be reopened unless there is an allegation that the assessee has not filed true and full particulars of the income. The second proviso said that no reassessment shall proceed or no notice shall be issued if the same issue is pending before the first appellate authority or before the second appellate authority. Am I clear to your lordships? There was no such. To put this, to fill up this lacuna in the statute, my lords, this legislation came. And the legislative intent is very clear. On the face of it, my lords, he said, the legislation said, first, conduct an inquiry. B said, give an opportunity of hearing. C said, consider the materials. Then, if you feel deemed fit and proper, then issue notice along with a form of 148. My lords, this is the legislative intent. Here, my lords, so far as the hearing is concerned, my lords, it is mandatory. I rely on a judgment of the Honorable Supreme Court, Institute of Chartered Accountant versus Ratan Lal, my lords. AR 87 Supreme Court, page 71, right. Para 16, my lords. There the Honorable Supreme Court said in para 16 of the said judgment by Justice Pathak, my lords, said that even it will, natural justice, unless is ruled out from the statute, it will apply even to the unoccupied fields of the interstices of justice. Before that, my lords is aware of Maneka Gandhi's case. I may not repeat that justice is not only be done, it has to be done. It has to be seen to be done. My lords, admittedly, my lords will agree.
Yes.
An opportunity of hearing which is provided under clause B. Here, my lords, the giving and hearing has not been ruled out. Hearing means physical hearing. There has to be an interaction. Why I am saying, my lords, I am relying on what will happen, my lords, post scenario of 148. Let us take an extreme example. An extreme example is to be taken, say 148 AD order is passed with a form, 148 notice. Then I have to file a return.
Correct.
Within the period stipulated.
Correct.
Lordship must have marked under 148, 30 days time was given for filing of the return. Then it was again by way of amendment said that no, as per the time stipulated, that is the amendment, which was later on brought. And now the same theory applies here, that the time limit as specified, I return it. Then what happens, my lords? I am giving your lordship the extreme example. Lordship has earlier has taken the view that I can participate, all my grievances can be mitigated, ventilated. Now, my lords, there is no scope for the assessee of hearing. Why I am saying, my lords? The faceless scheme, which has also come with effect from 142021, does not say about the hearing. My lords, I therefore request my lords to see section. It leaves complete to the discretion of the chief commissioner or the commissioner in charge. That's 144B.
If he considers appropriate.
He will consider.
Correct.
He will consider. That's it. Lordship will see clause 5, clause A to clause 5 of 144B.
Right.
The chief commissioner or the DG, Director General, or in charge of the regional faceless assessment center under which the concerned unit is set up may approve this request of the for personal hearing referred to in clause 7 if he is of the opinion that the request is covered by the circumstances referred to in subclause H of clause 12. So, my lords, the entire discretion is left with the Chief Commissioner. He may grant, may not grant. It is not mandatory on his part to give.
Right.
Then what will happen, my lords? Suppose, say, for example, I am giving a lordship, the assessee claims in his profit and loss account sundry creditors, say about, say, 2 crores.
Right.
And there are 20 sundry credits. Now, in order to establish this transaction, that is a loan transaction taken as from the sundry creditors, the identity is to be established.
Right.
The genuineness, lordship, remember 49 ITR, Srilekha Banerjee, Justice Hidayatullah's decision. That was the first decision so far as the 68 is concerned. The identity, genuineness, and creditworthiness. These 3 things are to be proved. Now, my lords, the DG does not give, or the Department of Revenue doesn't give. So these 2 crores will be added at the hands of the assessee as unexplained income, my lords. I think I am able to, or not able.
No, I was going to tell Mr. Karar that all these arguments are deemed to be included in the Wednesday arguments.
As your lordship pleases. Today is only
the bench will not change.
No.
Same 2 of us. So we have to hear. We don't want to hear the same
that
thing.
We are rather privileged to appear with your lordship.
No. I'm saying the arguments are so lucid.
No, my lords,
it will not suffer any repetition.
No, it will not suffer any repetition. So, my lords, the question of giving the mitigating or ventilating my grievance after the notice is issued under section 148A(d), then I cannot ventilate. This scheme has totally paralyzed the assessee.
Not quite.
Manners to some extent.
See, from the way we understand Punjab and Haryana,
yes,
all these grounds are just postponed for urging at a different stage. So when you question if after the 148, if he passes a reassessment order, which is adverse to you, and you challenge it in appeal, all these grounds will be available. That's what Jain says.
Appeal is also faceless, my lords. I understand. But, my lords, can these be provisions are just made to be bypassed?
No, not bypassed. So you may get out. This is like will be. I think earlier also you mentioned like a filtering mechanism.
Yes.
So some may escape now itself because the department is not convinced. So department agree with you at this stage and say, okay, let's drop the whole thing. No need to go for a 148. So this is for filtering out. This is a filtering out mechanism.
Filtering out. My lords, why the legislation brought? The legislative intention is to shortcut the process.
No, to reduce the burden.
Reduce the burden.
On both assessee and department.
And the department. Because till date also, my lords, we are approaching this honorable court, my lords.
Correct.
Say the assessment year 13-14 is being reopened now.
Right.
In 2022. And your lordship has been quashing notices.
Correct.
So this is a legislative intent that you have to hear. You have to hear. Unless, had that been the case, then this 144B that you should be afford an opportunity hearing could not have been there.
No, you're going to be heard in the assessment anyway. If it goes to a reassessment, you're going to be heard there anyway.
No, I cannot be heard, my lords. I cannot be heard. Lordship will have just now seen the provision. Such a voluminous document, my lords. Then, Lordship, I am requesting the commissioner that I want a virtual conference. I want to upload it in the website as well as I want to file the paperwork. And he decides, I am giving the extreme example. What will happen then? The only event is that.
See, there'll be no end to this. Then you'll say, let us time the hearing. It should not be like a.
Again, I have to approach your lordship.
Sometimes court hearing. That all over within 1 minute or 2 minutes. You'll say, what kind of hearing is this? He heard me only for 1 minute. You'll say that it should be minimum 5 minutes.
Yes.
Then you should say during those 5 minutes, he must be awake.
Yes. that I will not say.
And then, like American Supreme Court, you'll say if he interrupts me by asking questions, that will be excluded from 5 minutes.
That's correct, my lord.
So there's no end. So when we use the word hearing,
yes,
we'll have to see it in the context.
Yes. Now, my lords, one decision of the Rajasthan High Court, I will show to your lordships. I have already submitted before lordship that now pray my lords to come to page number 4. The last paragraph, we have heard learned counsel for the parties and peruse the records.
So this post Anshul.
Post date of judgment is
Post Anshul.
Yes, post Anshul.
Does it notice Anshul?
Not been on the. Well, let's also
review petition may be filed in this. Review petition may be filed in this.
By the revenue.
Correct.
It is for the assessee ballot.
Yeah, I know.
Malas, the revenue survives on the assessee. Unless we file a return, assessee file a return and deposit the amount.
That's true.
The revenue cannot run.
Correct.
All the salaries, everything will be stopped, my lords.
Correct. Correct.
So, my lords may kindly see. The Honorable Court has then extracted the section 148A. Then it comes page 6 of 13. The provision is explicitly clear. My lord, got it?
Yes.
That the assessing officer shall, before issuing any notice under section 148 of the Act, conduct inquiry, the details of which have been contained in subclass A, B, and C, which require seeking approval.
Prior approval.
Of clause D.
No. Something missing.
Approval, yes.
One line, bottom.
One line is missing, right?
Correct.
So perhaps from this computer.
Web copy.
Yes. This is very problematic sometimes.
Again, next line also. So all the bottom lines have gone.
Yes. Anyhow, my lords, the main portion has not been deleted. The expression material available on record has been consciously used by the legislature to put a fetter on the exercise of power in the manner that an order under section 148A of the Act deciding to issue notice under section 148 of the Act can be based only on the basis of material available on record. Therefore, the decision in the inquiry as contemplated under section 148A of the Act needs to be based on material available on record. The words material available on record in its just and fair and logical interpretation would only mean a tangible material and cannot be interpreted to mean remote likelihood of availability of material, it being taxing statute requiring strict construction, full stop. Then, my lords.
But Mr. Rai, this was a case of less than 50 lakhs. That was
this
the main.
is also a case.
No, the ratio is essentially that.
My lords, the present case is also, the present case is also of 18 lakhs.
All right.
Present case is also of 18 lakhs. It is not 50 lakhs. And one of the judgments of Delhi High Court, my lords, unfortunately, I have not been able to get it now. I have taken out the judgment, but somehow or other, it has been, somehow or other, it has
so
been
your
misplaced.
Wednesday clients will be luckier.
Yes.
Wednesday clients will be luckier. There, on Wednesday, you will cite Delhi High Court also.
Definite, man. I will. I have already prepared the ground and I will.
See, I knew. See, this is the thing we were anticipating. The second part of your sentence. When you said you'll part with the case, we were very happy. Now you said you'll part with it only till Wednesday.
No, I have got all the ammunitions. Mellors, I have also got a googly, which will completely uproot his.
Don't disclose it. I'm sure you're keeping it for Wednesday.
Yes, yes. And Mellors. No. By Mellors, the Punjab Haryana High Court, before I stop my argument, Punjab Haryana High Court has never noticed these provisions, has never discussed these effectiveness of this provision, never gone into the legislative intent, and therefore, Mellors, the endorsement by the Supreme Court cannot be said to be a law under section 140, under article 141 of the Constitution of India. It is not a precedent. It has no universal application. A constitutional court cannot be a mute spectator wherever there is a arbitrariness on the part of the executive. There are no 5 lakhs, already issue notice. Reject it. Then why the constitutional court is there, Mellors? Your lordship is armed with so many writs. It has to be used. It is not a precedent. Supreme Court has just said that that will only apply to the facts of that case only. It will never apply to other cases. Had it been so, Mellors, then after Supreme Court, Calcutta High Court has also delivered, division bench has delivered judgment. Lordship on the earlier occasion have seen it. I think. Am I clear to my Lordship?
No, it's very clear that your Wednesday preparation is very good.
So, Lordship, now for the present, issue notice and also stay for the like
between now and Wednesday.
It is up to you,
No,
Lordship.
just take list on Wednesday.
Yes.
But I am appearing this.
All the 3 are appearing, Mellors.
All right.
Obligement.
At honor 70.
May I please, your lordship, here I have challenged the demand notice under Annexure 3. The petitioner is an ex-licensee and demand notice is issued as per the audit objection for the financial year 2016 and 17.
So you can go before the commissioner.
Commission.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to approach the commissioner to challenge the demand at Annexure 3. Dispose of is withdrawn, liberty is granted. All right.
71.
71, my lord, kind pass over.
All right.
72.
May I please, my lords? The questions of law is at page 10 of your lordship's brief, my lords.
Yes.
Here, this is an interesting case. May I just, before I go to the questions of law, may I just put the facts before your lordship?
Yes.
The petitioner was a unit established under the IPR 1986, my lords. Then, my lords, it applied for a EMD, that's expansion modernization.
Last occasion, I have submitted one order.
Yeah, but that is not that order, my lords.
Both the
Okay, but let me just clarify it, my lords. Here, my lords, as per the expansion modernization diversification scheme, just because a new product was filed, it went for a diversification under IPR 1989, my lords. The writ which my learned friend was referring to for the assessment year, my lord, 98-99, my lords, that involved a case because in that particular DIC registration certificate for the diversified unit, it was fixed at 38 metric tons, my lords, in a single ship. The petitioner, my lord, produced more 38 metric tons. And he said that I was working in multiple shifts. And that particular aspect was not accepted by the tribunal. They said that since the DIC certification is for a single shift, we can only restrict.
So the demand here is 1.85 lakhs. You've already paid it.
My lords, that must have been paid, my lords.
You better confirm that because we are now going to entertain it after 13 years.
My lord, what has happened, my lord, this has a cascading effect, my lords. What has happened, my lord, interestingly, my lords, for 96-97, that has been allowed by the First Appellate Authority. No appeals have been preferred. For 98-99, it has been allowed by the First Appellate Authority. No appeals. This involves a period of 97-98, my lords. And interestingly, my lord, the very same composition of the tribunal which allowed 98-99, my lords, has rejected 97-98, my lords. What they have done
subsequently,
my lords. So the previous assessment year, my lord, they have allowed it. The subsequent assessment year, they have allowed it. The middle part, my lord, they have stuck it up, my lords. What has happened, my lord? This has a cascading effect. Why? Because this particular expansion, modernization, diversification, as your lordship knows, for 7 years, my lord. And in the present case, my lord, it was effective till 30th of July, 1999, my lords.
Anyway, notice has not even gone this. So
no, what has happened, my lord? Why? What they have done, my lord, is I've been given, my lord, of maximum capacity as per the diversified unit at 38 metric tons, my lord. My original capacity for a different product was 28.
Right.
What they did, my lord, is they said it will be only allowed for over and above 28, my lord. My humble contention, my lord, if the product is new, it's diversification. It's not expansion or modernization.
Right.
So in a diversified unit, my lord, it is 100% of the amount which has been given by the DIC basing on a new report, a new scheme and a new product which has been given, my lords. And that was accepted, my lord, for 96-97 and 98-99, my lords.
All right. Subject to the petitioner producing proof of having paid the demand. Notice returnable 5th April.
Your lordship, what my respected submission?
Not here, my lord, it is a case of total exemption, my lords.
No, whatever. If you succeed, you'll get. But there's right now a demand, right?
But there are 2 periods, my lord, which have already been accepted.
I know. But for the last, there's been no stay for 13 years now.
Both the assessment years, your lordship, the First Appellate Authority has said.
Sir, you want to examine it or today we want to have judgment?
Your lordship.
So notice returnable, he accepts notice. Same, subject to producing proof of payment of the tax demand. It is made clear that the payment would be subject to the outcome of the revision.
Pray for at least 6 weeks' time, my lord.
April, sir.
73.
It is covered in the circular. Only demand is 4,999,000.
All right. In view of the
28, 8,
19. Tax demand being below the monetary limit, tax effect being below the monetary limit, the appeal is disposed of.
74.
May please, your lordship, here below the order dated 2/4/2019 passed by the Honorable Single Judge. Blood has been referred to the Honorable Division Bench. Where below Oriental Bank of Commerce versus Meena Das case was below laid upon by the present petitioner. When below the Honorable Court has expressed below his view that though the Oriental Bank of Commerce 2015 OLR was that even the Consumer Protection Act matter, the appeal lies to Supreme the National Commission, but the Honorable Court has exercised jurisdiction 226 and also passed the order. But in the meantime, by relying upon the judgment of Andhra Pradesh High Court and other High Court, this Honorable Single Judge.
No, is it a final order of the Commission?
But it is a final order of the Commission.
Why can't you file an appeal?
Yes. In the meantime, my lord, fairly I just verified one SLP was decided. Where not just time to
just ask
the 12th of March 2021, because I was just going through this Honorable Court whether this Odisha judgment has been taken care, and also when no writ petition is not maintainable. So I should fairly submit that this is the present situation.
So that's okay.
Relying upon the judgment.
So you file now the appeal with a continuation of delay. In an order dated 12th March 2021, in SLP Civil number 4127 of 2021, bracket Mehra Bal Chikitsalaya, Evam Navjat Sishu ICU versus Manoj Upadhyay. The Supreme Court has upheld the view, reaffirmed the view expressed in Sicily,
my lord,
Kalarakal versus Vehicle Factory 2012 8 SEC 524, that a writ petition would not be maintainable against a final order of the State Consumer Dispute Redressal Commission. Packet. In that view of the matter, counsel of the petitioner seeks leave to withdraw the present writ petition with liberty to file an appeal before the National Consumer Dispute Redressal Commission in accordance with law. If such appeal is filed, accompanied by an application for continuation of delay, explaining the delay on account of the pendency of the writ petition, it will be examined on its merits by the NCDRC. The court clarifies it has not expressed any view on the matter.
By that time, very recently I just examined. This is the recent law, so I fairly just as to. My lord, the
writ petition is disposed of as withdrawn with liberties.
My lord.
75.
See, appeal is filed not later than 2nd January 2023. Right.
75 Lordship 17/8/2022. Notice is issued not. And
what happened? Nalco,
yes, I am appearing. Today we are filing Okalatnama.
All right.
And my lords, identical matters, that is ITA number 147 of 2018 and 149 of 2018. Both are posted to 15th of March 2020.
All right. List on the Wakalatnama of the counsel for the respondent is taken on record. List on 15th March 2023. Along with ITA numbers
147 of 2018 and ITA number 149 of 2018.
147 and 149 of 2019.
IA 11/19 may be disposed. Dispense with this.
IA 11 of 2019 for the reason stated therein, it's allowed. It's disposed of. Allowed. That's it.
76.
In this case, last again, last order, 15/9/2022, lordship directed additional comment advocate to take instruction so far as the additional affidavit filed by the petitioners regarding recommending the 22nd 12/20 regarding
what happened, Mr. Monty?
To declare the petitioners are displaced persons.
Some more time.
That instruction.
Yeah, Mr. Monty seeks some more time for instructions.
Sir,
his request is
copy has not been given. The additional affidavit. I am appearing for OP number 4, but they have not served a copy on me actually.
All right. Copy of the right in the beginning. You say copy of the additional affidavit of the petitioners be served on Mr. S.P. Mishra, senior counsel. appearing for opposite party number 4. Then you say Mr. D.K. Mantil on AGA. Seek some more time for instructions in terms of the previous order dated 15/9/2022.
15/9.
That is request list on
the 15/9. It was posted to Lordship.
15th March 23.
77.
My Lord, by order dated 12th July 2022, Your Lordship has directed that when the land recorded in name of private person for the government has already been cancelled, how there is no occasion that it still stands recorded in his name. On that point, the learned government advocate was directed to obtain instruction. The order dated 12 July 2022.
Let me kindly pass over.
All right.
The Lordship may kindly call it next week, my Lord. I have some difficulty today.
All right. The Manti seeks some more time for instructions.
No, instruction is there. I have to just checking. Just one pass over. After
next week, just some difficulty.
No, there is a interim stay.
No, no interim.
There's no stay.
No stay.
You said the request of learned counsel for the learned AG list on 15th March 23.
My Lord may call it next week, Your Lordship. I'll get it.
You don't have the time, sir.
1 week after, Your Lordship. Only small matter, Your Lordship.
I know. You don't have the time. Yes.
78.
My Lord, in this case, I have filed an petition for amendment, my Lord. During pendency of this case, some development have taken place which needs to be brought on record, my Lord. I have filed that amendment.
Okay, 14131 of 2022 for the recent state the application is allowed. The amendments is prayed for are permitted to be carried out. The consolidated petition be filed within a week. Then you say list on January.
79
lots. In this case, I am appearing for OP number 5, 6, and 7. Even though I had taken time to file counter, due to want of some document, I am not able to file it. I need some 3 weeks more time to file counter.
Your Lordship may have a glance the order dated 25/7/2022, my Lord. On that date, my Lord, 4 weeks time was granted and the case was posted to today. Now, my Lord, while not filing the counter, they are proceeding with the in accordance with the notification which is under challenge before a Lordship.
My Lord, in this case, we have filed the counter yesterday.
Yes, government has
will serve copy on all the councils.
Or it's not come on record also.
Yes.
The reply stated have been filed on behalf of opposite parties.
Formally.
Government, state government.
No. 1, 2, and 3 be placed on record and also served on council for the 1 to 4.
Service
also be served on council for the other parties. Paragraph. Council last opportunity to opposite parties 5, 6, and 7 to file the reply within 4 weeks. Rejoinder to both, if any, be filed for the next date. 22nd March.
Then your Lordship may Annex 3 may not be given effect to, or that may be kept in abeyance. Your Lordship, with that notification is on challenge. By virtue of that notification, my Lord, they have tried to supersede the RR policy. That is
okay. No need to stay and all that. Yes.
That will allowing the
right.
Any date earlier to that, my Lord, because 3 months time was granted.
It's all right. We've said last opportunity. All right.
Item number 80.
May I please, Your Lordship? Your Lordship, this is relating to the HSRP PIL, a fixation of HSRP. Your Lordship, may kindly recall on the last date I submitted.
Kindly recall the order dated 26th of October.
I may kindly be permitted
memo
to
has been
submit, Your Lordship.
Petitioner.
Let her finish.
Your Lordship, on last date I submitted that there are no slots available. And to that effect, a memo was also filed. Your Lordship directed my learned senior to file an affidavit and the affidavit was filed. Your Lordship, may kindly look at that affidavit, page 18. I'll straight away take Your Lordship's attention to page 18 of that affidavit. The affidavit was filed on 29th October by opposite party number 2. Preliminary counter affidavit.
Where is that? Doesn't come on record, I think.
It is at flag. Your Lordship may kindly see the noting. Written instructions dated 20. No, probably it is not there on record. Your Lordship may kindly, if I may be permitted this copy, maybe.
Okay.
The preliminary counter affidavit has been filed stating that these many slots are available, Your Lordship. Your Lordship may kindly note starting from 15th November, only in thousands, barely 2,000, 4,000 slots are available. Your Lordship, by rejoinder affidavit that I filed today, Your Lordship may kindly see the statement that I filed of the number of vehicles registered.
We don't even have this affidavit now.
That I'm submitting.
This is the rejoinder, but we don't have your affidavit.
May I provide
the statement of the number of vehicles registered in the state of Odisha? The brief.
48 lakhs.
Yeah, no, that is for this year 2010. Lordship may come to page 3 of the affidavit. I have given a summary.
No, that's what the total is 48 lakh vehicles.
Yes, 48 lakhs, that too until 2010-11.
No, 18-19.
Yes, starting from 2010-11 until 18-19.
There's a total of 49 lakhs, 48-19.
Yes, Your Lordship. And keeping in mind, Your Lordship, the fitness of a vehicle, which is up to 15 years. So even in back calculation, if we hold from 2007-8, my calculation roughly will be 49 lakhs plus 15 lakhs amount. Per their counter affidavit that they've. And Your Lordship, the press release at annexure 9, page 22
we don't
of
have
this.
That affidavit.
Your Lordship, I refer to this affidavit, annexure 9, page 22. The one that I filed, the rejoinder affidavit.
Yes.
Page 22, Your Lordship, the last paragraph. Second line I'm placing.
Yes.
As on 14/11/2022, a total of 31 lakh vehicle owners have booked slot. Out of which HSRP has been affixed in 15 lakh some odd vehicles. Your Lordship, my submission is keeping in view the number of vehicles, the motorbikes and the cars and every vehicle is taken care of. It is somewhere around 50 to 60 lakhs, Your Lordship. Half of them have not been registered. And Your Lordship sees that the number of slots available are merely in thousands. So that will not solve the purpose that my learned senior is trying to bring to Your Lordship's notice.
Yes.
So by submitting, my learned friend has sought for extension. Not here, Lordship may find that press notice. In respect of different vehicles, the deadline has been fixed. Lordship, my last notification, that is, my affidavit is there in the noting. But 29/10/2000.
Which noting, sir?
Annexure.
Which flag is your affidavit?
My lord, I have filed on 29th of
Your Lordship, this is
October.
the same notification that my learned senior is referring, that is there at page 22. Effectively, the dates have been extended, and that's what my learned senior is trying to refer to.
Vehicle ending.
Yes, Your Lordship. So 1, 2, 3, 4 ending on
my respectful submission, my lord. In the meanwhile, I will provide the data where the slots has been, my lord, the booked and the registration certificate, my lord, has been affixed.
The difference is huge, Your Lordship.
Not,
when the number of vehicles.
Find the current data, my lord. Not the statement showing the number of vehicles booked for HSRP as on
my lord, 20th of November 2022. Lordship may find. So the number ending registration number 1, the approximate vehicle is, the total number is 5 lakhs. My lord, that out of that, some of the vehicles not existing now, my lord. But the booking is, my lord, 35 lakhs and that is 35 lakhs and 927 million. And about 70% vehicle has been booked. And that way, my lord, all the vehicles registration number has been there. Lordship may find at least, my lord, 63% of the vehicle has already been booked. And only remaining 36% is there. And the last date is, my lord, 28th February 2023 million. So there is no justification for extension of time. In the second
happens 28th February still sometime.
No, Your Lordship, the numbers ending 1, 2, 4 are ending on 30th 11. The one that my learned senior is referring to, that is number ending 9 and 0.
Oh.
So that might
then there's discrimination, isn't it?
No, my lord, in the next statement, Your Lordship kindly find. But
no, there's discrimination. If one vehicle is ending 1, another vehicle is ending 9, that man will get 4 more months.
Yes, also, my lord.
So why have this kind of a logic?
My lord, logic is in the phased manner.
No, so, but then the number 9, by fortuitously, gets more months.
So
no, I'm saying if you happen to have a 9 number, you'll have time till end February. There's no logic on that.
If I may,
I think you should, without this vehicle number ending, you should give time till February.
My lord, that is there, my lord.
Your Lordship.
In the next statement, Your Lordship kindly see, my lord. Next, my lord, when the date has not been extended, the booking is, my lord, 2,13,245.
Your Lordship, all these.
Then, my lord, after extension, that has been reduced. My lord, on September, the booking is 14,58,466. And October, my lord, when the date has been extended, till November, the booking is, my lord, 1,89,000. And in case Your Lordship will extend the date, there will be no booking.
We are not extending date. You are extending date, sir.
No, my lord.
We have extended date. Till date, we have not extended date. You have come and told us we are extending date.
So, my lord, extension is not justified now, my lord. At least there are 30,000 vehicles can be booked in a day, and there will be, my lord, enough fitment center has been provided in the state.
Your Lordship may kindly see the affidavit.
Absolutely
slots that are
there is absolutely no difficulty for the owner.
Affidavit filed
for fitment, my lord.
Page 20.
There is absolutely no difficulty for the owner.
The preliminary counter that they filed, the slots available are merely in thousands, Your Lordship. Unless there are slot bookings, I cannot book. And Your Lordship may also see at annexure 10, page 24 of the rejoinder affidavit that I filed.
And Your Lordship knows the Honorable Supreme Court has,
from the state
Supreme Court has fixed the deadline till 2012 is the last date for application.
2018. It's already taken 4 years.
That I have filed the counter affidavit in the meantime.
Your Lordship may kindly see third paragraph, page 24 of the rejoinder affidavit.
Yes.
State government has written it to the Transport Commissioner. In view of above, you are requested to assess the number of old vehicles, the capacity of HSRP manufacturers to prepare and affix HSRP in a day, and calculate the time required to affix HSRP in all such old vehicles, and refix timeline accordingly after due approval by the government. Steps may also be taken in consultation with HSRP manufacturers for fixation of HSRP in vehicles whose original manufacturers have closed down their business in the meantime. Further, you are further requested to ensure through RTOs that the high security number plates supplied by the manufacturers are in compliance.
Have you replied to this?
My lord?
Did you reply to this? The letter was asked, written to you, Transport Commissioner, by the Joint Secretary.
Yes.
Have you replied to this letter?
Rejoinder.
No, my lord.
The rejoinder, page 24.
Just now he has solved the copy.
That copy you see, sir. No harm in just seeing it.
Yes.
Annexure 10. Page 24.
My lord, annexure 10 is not there. My lord, here.
Okay.
Yes, yes, yes.
Have you replied to that letter?
Lord, in pursuant to this letter, last extension has been granted.
When?
Lord, that is on 29th Jan of 2022.
No, but have you replied?
My lord?
Have you replied to the government, sir?
Well, that I have to take into consideration.
You say counter affidavit has been filed. A preliminary counter affidavit dated 29th October 2022 has been filed, stating inter alia that vehicles with different number endings have been given separate slots for registration for the purposes of affixation of HSRP plates. The last of these slots is for the vehicles with the number ending 9 and 0, for which the deadline is 28th February 2023. So, however, for vehicles ending with 1 and 2, the deadline is day after tomorrow, that is 30th November 2022. In the rejoinder affidavit handed over today in court, the petitioner points out that of the total number of nearly 49 lakh registered vehicles, given the total number of registered vehicles from 2010-11 in the state of Odisha is around 49 lakhs, the daily availability of slots for fixation of HSRP plates through online applications is only in thousands, and which is therefore woefully inadequate. According to the petitioner, these deadlines, the date lines by the transport department are unrealistic. It is seen, along with the rejoinder is a copy of a letter dated October 2022 written by the Joint Secretary to the Government, Commerce and Transport Department to the Transport Commissioner Odisha, inter alia, asking the latter to assess the number of old vehicles, the capacity of HSRP manufacturers, and to open quotation, refix timeline accordingly after due approval by government, unquote. Counsel to the Transport Commissioner is unable to inform the court whether this letter was replied to Transport Commissioner. We'll keep it on 30th. He needs time for those. He accordingly seeks for a short adjournment. 30th, we'll keep it on 30th.
Not much after that, time has been extended. That letter was issued on 6th.
Simple question I'm asking you. Show us the reply to this letter.
I'll
reply.
I'll submit.
30th November. Right.
Obliged to lodge.
I appear for the petitioners. My lord, 81. Item 81, Mr. Yogesh Patki will be the arguing counsel. 1259, 2304, 2305, 6282, and 220. 5 petitions. The main petition is 1259.
Beg your pardon, Your Lordship. Your Lordship, this case may be taken up on some other day, Your Lordship. This item 81, I have issued a letter to take some instruction from the government. It is that IOCL exemption matter, Your Lordship. Your Lordship,
These are all connected matters.
He is awaiting written instructions on the present matter, as regards the present batch of matters. There's some interim order, is it?
We have deposited, we have been told to deposit around 48 crores we have deposited for interim order in all those cases.
Interim order to continue.
Yes, I am there in this matter in the last 3 matters, Lords. And all other applications, Lords, I have filed intervention applications. Lords, if I kindly turn to the next page. CMPL 5 by 2020, CMPL 6 by 2020, and CMPL 7 by 2020. So in the meantime, I have already small defects are there. I have removed that, and I have one copy yet to be given. I have given one more copy to Lordship. Because the defect is 1 copy is given. So other copy. Yes, your Lordship have directed me to file this substitution liquidation order and substitution application, because that could not be filed. Your Lordship dismissed with a liberty that if I file restoration application within 30 days, the same shall be considered. And I have filed the CMPL within 30 days. I have given to your Lordship a copy of the order, my lord. Order dated 11/12/2019. So my humble prayer, your Lordship may kindly restore this application. And so far as
where is the order?
It's 11/12/2009. That is there in 11/12/2019. Division. 2 copies of my Lord's order I will given. If so advised, petitioner.
Eleven 12/2019.
2019.
In which it's a CMAPL.
CMAPL. I have also filed within that time, Lords. That 30-day time which your Lordship have granted liberty, Lords.
Okay. CMAPL 5 of 2020. A memo has been filed placing on record a copy of the CMAPL, which is free of defects, with the copy being served on the counsel for the department. Since stated therein, the application is allowed. Order dated 11/12/2019 is and writ petition civil 17271 of 2015 is restored to the file along with the interim order. Passed therein. Same order in 6 and 7.
6 and 7.
So only writ petition numbers will change.
Minus CMPL 6.
All right. And then in all these petitions, you say list along with.
There are 2 more IS Lords, which your Lordship was also pleased to allow substitution along with condemnation. I have given a copy of my Lord's order, Lords. In case of this petition, other case, Lords. Only substitution because now the liquidator has taken charge.
Where are those IAs?
Sorry?
Where are the IAs? You said there are 2 more IAs.
2 more. These are there, Lords. In all cases, your Lordship may kindly see from the start of IWPC 125/2012. In all these cases, Lords, this interventional application along with substitution and also condemnation delay is there.
All right. So all those IAs you put together. MC number 17011, 1090 of 2012, 6800 of 2020, 6801 of 2020. You say the delay in filing the substitution application is condoned. For the reason stated, the substitution is allowed as prayed for. The intervention is also allowed as prayed for.
Right.
All these applications are accordingly disposed of.
Whereas in these 3 CMPL application Lords, I have, prior to filing this, I have also filed substitution and condemnation, Lords.
I have allowed all of that.
I know. My lordship, kindly mention that WPC number 3136, 3137 and 17271 up to 15.
Right. That, yeah.
Apart from the all others, my lords. Much obliged, my lords.
So
my appearance may be noted, my lord. I am for Indian Oil Corporation.
2012 petitions will
list on 12th April.
Lordship, earlier, 2012 petitions.
Goes on getting adjourned. What to do, sir?
Interview to continue in all matters.
Yeah.
My lord, my appearance may be noted, my lord. I am for Indian Oil Corporation.
All right.
Actually, April.
82.
May it please your lordship, this both the periods, that is 1/4/2011 to 31/3/2013, that is 42 and 43 sections, that is, and 1/4/2014 to 31/3/2015, directly 43 assessment has been made without taking the assessment 39 and 40 and 42.
Keshav Automobiles. What is it? Keshav Automobiles.
Your lordship. Your lordship.
Order, you handed over some order in that earlier one, bunch of matter. There's an order there.
Your lordship, here.
IVRCL. No, that loose papers which I did in the previous matter. Just show me those loose papers. The end of it.
Your lordship, case of automobiles.
The top, that order is there. Take it up.
Your lordship, in this case.
No, I think the top order is that one. No, sir. Yes.
Your lordship. Your lordship, in this case, this is the assessment order under section 43, your lordship. Your lordship, case of automobiles is there, your lordship. Some factual distinction, I may be permitted to make some factual distinction for within 1 minute or 2 minutes, your lordship.
No, take 3 or 4, no problem.
Your lordship, at page 18 of the assessment or page 18, your lordship, there are 2 periods. One is 1/4/2011 to 31st March 2013. It is not, your lordship may kindly turn to page 18.
Yes.
So 1/4/2000 to 31st March 2013, that is not disputed because 42 assessment was there. Now, your lordship, the only period is 1/4/2014 to 31st March 2015, your lordship. So for this period, 39 assessment under self-assessment under section 39 was there. How, your lordship? Your lordship, in the same paragraph, the last 4 lines, the dealer in the instant case is a limited company and filing monthly return of OVAT, CST and ET, and the same were accepted as self-assessed under section 39 of OVAT. The dealer has been assessed 42. So, your lordship. Now, your lordship may recall, your lordship, that case of automobiles case, your lordship. That case of automobiles case, your lordship may kindly turn to paragraph 22. Your lordship may recollect, your lordship. Your lordship has stated from the above discussion. The picture that emerges is that if self-assessment under section 39 of OVAT Act for the tax period prior to 1st October 2015 are not accepted either, your lordship, either by a formal communication or an acknowledgement by the department that such assessment cannot be subjected, sought to be reopened under section 43(1) of OVAT Act and further subject to the fulfillment of other requirements as per the provision. Now, your lordship, in this case, your lordship, these are the acknowledgement have been issued after filing of the return. Your lordship, so your lordship has clearly stated that accepted either by way of formal communication or an acknowledgement by the department. So at the time of filing of the self-assessed return, your lordship, the formal acceptance that the acknowledgement is there. And in the order sheet, your lordship, in the order sheet itself says Seeing the marginal load, the return for the tax period from 1/4/2014 to 31st March 2015 are self-assessed under section 5 and it is accepted. Your Lordship, I may be permitted to submit the
No, we
record.
have said or an acknowledgement.
The record, Your Lordship. So what Your Lordship might recollect that 3943 in that case of automobiles case, Your Lordship, even though I have argued the white paper, etc., and the amendment. Since 39(2) has been amended, the deeming provision has been amended with effect from 1/10/2015. So Your Lordship has clearly stated that that interpretation cannot be prior to 1/10/2015. Your Lordship, that is admitted, and Your Lordship, and that has been confirmed by Honorable Supreme Court. But Your Lordship, so far as the self-assessed, what Your Lordship, what is the meaning of self-assessed, Your Lordship? He has filed the return, acknowledgement has been issued. There was no arithmetical error which is sought to be required to be rectified. For that, Your Lordship, all those returns have been accepted, and after acceptance, Your Lordship, only these 43 notices have been issued, Your Lordship. So for that reason, this may be a separate case, not as like as case of automobiles.
I'll give you a copy of this.
They have not communicated to us so far. No, communication, Your Lordship, has not given the emphasis so far as communication is concerned. This is self-generated. This is automated. Not like income tax, automated. They have to communicate that certain and they have accepted. No, Your Lordship, on the last system, on that day also clearly stated that communication may not be required, Your Lordship. Communication required.
What's the language of the statute? Right. Let's see the language. It's there. We'll set it out in this.
Your Lordship. Right. Your Lordship, but
let's set it out to the judge.
Your Lordship, at paragraph 22, page 10 of the order. This is only case of automobiles, Your Lordship. Communication. It's in an empty bracket. And Your Lordship, at paragraph 21, page 9 also, Your Lordship has started the finding.
No, but the statute says 39(2). If a registered dealer furnishes the return, see 39(2) prior to the amendment.
Your Lordship.
Read it.
30, even scrutiny of return, the 38, Your Lordship. Once 39, Your Lordship, 39. 39 language is that if a registered dealer furnishes the return in respect of any tax period within the prescribed time, the returns of furnished is found to be on order, it shall be accepted as self-assessed subject to adjustment of any arithmetical error apparent on the face of the said return.
Shall be accepted.
Shall be accepted. Your Lordship, that shall be accepted, Your Lordship. So, by way of acceptance, that acknowledgement has been issued.
Acceptance is something different from receipt.
Yes.
To distinguish.
And Your Lordship, at paragraph 22 has clearly either it shall be.
That acknowledgement also has to be like applying a mind, not a mechanical, just a receipt.
No, Lordship, what is the
acknowledgement of return is different from just acknowledging receipt of the return.
Your Lordship,
somewhere, see, something has to be indicated.
Your Lordship, I can understand.
That somebody has read it and somebody is accepting it.
Your Lordship, self-assessment, Your Lordship, after deeming provision, there is no problem. Your Lordship,
it's like this is equivalent to just putting a rubber stamp, receipt.
Your Lordship,
that's not enough.
Because Your Lordship.
No, but we don't know that. He doesn't, at least SSC does not know.
If 38 and 39 analogous reading, Your Lordship, so then it is. So it is itself self-assessed.
No, it's found to be not. It's found to be in order.
Found to be in order. We are saying in order. We are not disputing that it is not in order. There is no arithmetical stuff, mistake or anything. So notice is to be issued. So for that reason, that returns have been accepted, and subsequent to that, 43 has been initiated.
What do you say, sir?
This is only acknowledgement of
returns. So he says this won't be issued unless it is found to be in order.
Yes, when communication, now it is communicated to me, only the acknowledgement. Returns acknowledgement.
No, how do we know
What order
this is available to him?
Is not known. This is once returns have been filed, Your Lordship, this is acknowledgement. This is acknowledgement receipt. He can generate from his
How do you notice that? He's now saying, I've never seen it.
It is acknowledgement received once we have, but this is online filing. Since after 2010, it is online filing. Once you file the return, Your Lordship, that it has been generated the acknowledgement since that 139 acknowledgement of income tax as like us.
No, but Keshav Automobiles also that period only.
Your Lordship, that period is there. Your Lordship, in that case, Your Lordship has pointed out that even there is no acknowledgement has been
only acknowledged.
But here, in this case, acknowledgements have been issued.
Return acknowledged.
Yes, return acknowledged.
Only filing of return is acknowledged.
What else? That's what he's saying.
Where is order?
That is
what else should happen here? He's asking. What else should happen?
Only this is acknowledge the return.
Correct. He says it amounts to acceptance of your return because that's how you're getting acknowledged.
Acceptance return nowhere return is accepted. It's not automatic process.
They received this, it accepted.
Circular or something or notification.
Clearly
Commissioner made filing of e-filing made mandatory.
You Lordship, that 2009, you Lordship.
No, it's not 2009. It must be 2011 and onwards, somewhere.
Mandatory filing. You Lordship, in that case,
E-generated returns are.
Para 9 of Keshav Auto. Come to para 9 of Keshav Automobile.
Your Lordship. Your Lordship, in that case, I have submitted. Your Lordship.
You said what we recorded in Keshav Automobiles was change was brought about in 2010.
Your Lordship, in that case, Your Lordship has pointed out that whether any acknowledgement has been issued or not. In that case, so we could not produce those acknowledgement. For that reason, Your Lordship, at paragraph 22 has categorically stated that either by way of formal acceptance or acknowledgement, nothing has been issued. Your Lordship, for that reason, Your Lordship has passed the order. Your Lordship might have remembered. Your Lordship, on that occasion, this particular question have been raised by Your Lordship.
Now, section 43, my lord, have a glance to it. After a dealer is assessed under section 39, 40, 42 or 44, any assessment, then the assessing authority may go to 43.
Self-assessment is a different concept.
It's only return file that is sufficient. But what happened there?
Verify that.
How I can verify whether my return is
because you look into your portal, you will get this acknowledgement.
Just
this is generated from your portal only, sir.
They have to communicate me.
How? The online system, it comes from your system. No need for further communication. In an online system, it will just simply land in your inbox. So now you have to argue independent of Keshav.
Thereafter also, in case they go to 43, my lord, they have to serve notice of any under assessed concealment or assessed at lower rate. Notice they have not issued to me so far. No.
How without 43? Yes, Your Lordship, my record is there. How without 43 notice, Your Lordship, that is there, Your Lordship.
What notice have issued? Who has acknowledged? Nothing has been done.
Your Lordship, may kindly turn to page 19.
So anyway, in his case, it is a record that original file is returned.
Your Lordship,
not this, sir. 1 minute. Understand what I'm trying to say. He gave an original file.
Your Lordship, that is the original file. That yellow color.
That kindly returned to him. Ask this man to return it to him.
Your Lordship.
No, you pull out. What he's saying, no notice, you have proof of notice.
Your Lordship, that is also in the assessment page 19. That notice issue notice to the dealer and that in fixing the date of his the stage of 15. Your Lordship, the notice have been issued and he has given the reply. Sir.
Who period?
All the periods. Both periods. All the
Notice on the section. What is section? Notice under assessed or wrongly assessed or low return. Escaped. What under assessed? Here is
you have appeared. Your Lordship, this is the notice, and pursuant to the notice, he has appeared. Your Lordship, for production, the dealer show after availing several for hearing of the confrontation finally appeared on 20. Your Lordship, at page 24. Sorry, 19. Your Lordship, that paragraph, upon information so and so, the dealer, after availing the opportunities for hearing, filed appearing so on dated 24 February 2016, submitted the written submission, employer citing a number of judgments.
All the notices been served. All right. What else, sir? 2 points over. Now, third point.
My that is.
My friend Mr. Ponda wants me to, if your Lordship permit, just one line.
One line that
with my Lord's kind permission. That's now the argument of Mr. Mishra, what I find is totally intended to overreach the judgment of the Honorable Apex Court, which affirms your Lordship judgment. The reason being, my friend's argument is the acknowledgement which is issued by the department on filing of a return constitutes acceptance, Milords. The term acceptance, Milords, your Lordship has dealt in the scope of section 38, which provides for scrutiny of all returns. All the section 38 says each and every return filed by a registered dealer shall be scrutinized. And section 39 is the provision of self-assessment, Milords. Section 39(1), summary procedure, then 2 Milords, and your Lordship have also read alongside 39 rule 48 Milords, which
if you read para 9 of Keshav Automobiles, I think there's an acknowledgement that this was a pre-online compulsory filing. Just see para 9.
Exactly, that's what I'm hearing. On the other hand, kindly your Lordship bear with me, Mr. Sudhil Mishra, an additional standing counsel for the opposite party department, submitted that the first level change was brought about in the OVAT Act in 2010, when all the returns had to be filed only online. Therefore, the actual acceptance of the return in physical mode was no longer possible. If the return was defective, notice should be issued to the assessee to rectify the defects. Otherwise, the returns filed under section 39 of the Act by way of self-assessment and was deemed to be accepted. He placed reliance on certain portions of the white paper on state level value-added tax brought out by the empowered committee of the State Finance Commission on 17/1/2005. Your Lordship rejected the entire commission. But your lordship said that had this online acceptance would have been there, this could have been included.
So in Keshav, they were unable to show us online acceptance.
Yes, sir. Now the argument of Mr. Mishra, you
No. So if you come now to para 22.
Para 22, my lord. From the above discussion, the picture that emerges is that if the self-assessment under section 39 of the OVA Act for the period prior to 1/10/2015 are not accepted either by a formal communication or an acknowledgement by the department, then such assessment cannot be sought to be reopened under section 43(1) OVA
Or
Act.
an acknowledgement.
But now the formal communication or acknowledgement. So acknowledgement not return me not. Because the reason being, supposing today I am filing the return either by electronic mode or manual mode.
Online.
Either of it you will kindly bear in mind. But at the time of filing of return, the assessing officer has no scope to go for scrutiny under section 39, under section 39, 38 for scrutiny, and 39 to find out whether the return so filed. Instantly he cannot application of judicial mind. Whether the contents, what he is going to at the end of the day see, whether the particulars, information available in the return minutes are found to be correct, whether he has applied correct rate of tax, whether turnover he has disclosed on which he has paid tax, or whether appropriate interest is paid, appropriate deductions are claimed, input tax paid are appropriately available or not. Those are the matters he has to apply his mind. And if there is an arithmetical error, some corrections required, he has to issue a notice requiring the assessee to respond to the notice. Assessee has also, in turn, under the Act, has the privilege to make corrections, to make compliances. If all these things doesn't happen, ultimately that will be referred to.
So you are emphasizing on the words, if it is found to be in order.
Exactly.
That can't be a mechanical thing according to you. Suppose
exactly.
I file it at, let's say, 3:10 p.m.
Right.
And this is generated at 3:10 p.m. itself.
Not 3 p.m. itself.
The moment I file, the right of acknowledgement will be immediately generated.
Exactly, generated inside. So therefore,
there will be no occasion to examine to see if it is an order.
Absolutely correct. Yes, therefore, you will reject the content, sir. Because there cannot be an acceptance. The mind must be in order.
Imposition.
That was the communication of that acceptance. Acceptance is not a matter of course. That was the application of judicial mind. And had this been matter after 1/10/2015, matter otherwise.
Yes.
Your lordship confined by not judgment only to matters prior to 1/10/2015, not beyond that.
Your lordship, now your lordship, after 1/10/2015, my lordship's argument is that there is nothing. Your lordship, may kindly turn to 38. What section 38 says? 38 says, your lordship, each and every return. Your lordship, but that reason, your lordship, the language is self-assessment. 38, your lordship, each and every return in relation to any tax period furnished by a registered dealer under section 33 shall be subject to scrutiny by an assessing officer to verify the correctness of calculation application.
No, but here also 39(2)
your lordship
requires you to find out if it is an order.
Exactly. No, your lordship prescribed time and returns of furnished.
Not this level of scrutiny.
Yes.
There's a difference between a 38(1) level of scrutiny
your lordship
and a 39(2) level of scrutiny.
38(2), your lordship, when there is any mistake, only notice can be issued.
So don't go to 38 when we're talking of 39. All right.
Your lordship.
38 is you have picked up a return for scrutiny.
No, your lordship, your lordship.
Sir, please, there's a difference between a self-assessment. 38 is when you have picked up a return for scrutiny.
Your lordship, as scrutiny any mistake.
That is the self-assessment, sir.
Your lordship, self-assessment. Your lordship, what is the self-assessment? Self-assessment means the return, what the dealer has filed the return by making assessment of himself.
This is your desperate attempt to somehow wriggle out of Keshav automobiles.
My intention is not to review. I have no authority, your lordship. I have no authority, your lordship.
No, but it's a good attempt. You have an attempt. That's what all advocacy is all about. That.
Your lordship,
If your lordship would see the rules. If your lordship would see the rules, Lord, this automatic scrutiny leading to 43 was introduced after 1/10/2015 conscious.
Yes.
If your lordship would kindly see Rule 40 minutes. The scrutiny leading to 43 assessment was introduced by sub-rule 3. Rule 40, if your lordship would see the notes. Lordship got it?
Yes.
It begins with scrutiny of returns. So this subrule 3 was added with effect from 1/10/2015. So they say when the dealer fails to comply, this is also including a system-based scrutiny. So when a dealer fails to comply with the defects pointed out at the time of scrutiny of the returns furnished for a tax period within the specified time, or mistakes are found to be deliberate with an intention to evade tax, such returns wherein mistakes are found shall be assessed at a 43 million. So scrutiny leading to automatic 43 million was introduced with effect from 1/10/2015.
Correct.
So that's why your lordship. That's why
He has only received.
so that's why your lordships are consciously in Keshav Water said.
No, and even this change after 1/10/2015 in 39(2) itself, the whole concept of deemed. The deemed solved all your problems.
My entire argument on that, and the deeming provisions should be retrospective because that interpretation was there by in 1/10/2015. समिति होगा The state loses so much of revenue because due to this, your lordship,
it all becomes insignificant. These days, the figures are all different.
Your lordship, sometimes I've given guilty to me myself that what mistake, whether I have done mistake or not.
That's why there are levels of scrutiny. We ourselves cannot be sure, so we also look up to Supreme Court. So you say in the present case.
So your lordship, if not accepted my submission, your lordship, definitely your lordship is not accepting my submission.
Correct.
So what for that reason, your lordship, this order can be set aside to the assessing officer. But why your lordship? Because for the part period, because there are two periods, one assessment, two periods as per 1/4/2000, that is the period your lordship may pass per page 18.
Yes.
1/4/2011 to 31st March 2013. That 42 assessment was there. Prior to that, 42 assessment is there. So this 43 is justified. Since 42, my Lawrence Senior will not object. Pending on the tribunal. Wherever maybe. So my Lawrence Senior will not object that, your lordship, because 42 is there and the prime parameter of 43 has been fulfilled. Now, your lordship, so far as the other part, 1/4/2013 to 31st March 2015, it is I leave it to your lordship.
Okay. The challenge in the present petition. You say admit. Sorry, don't have to say. You say the challenge in the present petition is to an order of assessment dated March 2016 of the
Your lordship may record submission.
Deputy Commissioner of Sales Tax bracket DCST Rourkela 2 circle for 2 periods of assessment, that is 1st April 2011 to 31st March 2013 and 1st April 2014 to 31st March 2015. Stop. At the outset, it's pointed out that as far as the assessment for the tax period 1st April 2011 to 31st March 2013 is concerned, it was preceded by a regular assessment under Section 42 of the Orissa Entry Tax Act. Sorry.
No, so Orissa valued Orissa 42 to 18, page 56. Page 56.
This page 18, first line.
10,147 repetition that relates to
OET.
OET.
10,347. 47.
Let's see,
this is bad.
10,347 is OET. 10,349 is OVAT.
Yes.
But my case and all the annexes.
No, you may.
This is I have. This is
especially the annexes.
Wow.
So we'll dictate in the other one then.
OET will be under covered by
ECMAS.
ECMAS reason.
Not Keshav.
And this is the OVAT. The other one
Yes.
is
Both my numbers have been, I think, yes, numbers have been wrong.
All right. Just first take down in 10349. The challenge in the present petition is to an assessment order dated 15 March 2016, passed by the Deputy Commissioner of Sales Tax, Rourkela 2 Circle, in respect of two assessment periods, that is 1st April 2011 to 31st March 2013, and 1st April 2014 to 31st March 2015. Paragraph. It is an admitted position that as far as the first period, 1st April 2011 to 31st March 2013 is concerned, the petitioner dealer had already been assessed in respect of that period under section 42 of the Orissa Value Added Tax Act 2004 bracket OVAT tax. Stop. After the special investigation team conducted an inquiry, certain discrepancies in the books of account were found, and a tax evasion case report was submitted. So on this basis, the assessment was reopened. And as a result of that reopening, the impugned assessment order has been passed. Stop. Paragraph. It is an admitted position that the impugned assessment order was separately challenged in an appeal, which is now.
No. Let's see. This is the 43 assessment for 1/4/2011 to 31st March 2015. So this 43 assessment, prior to this 43 assessment, that ingredient 39, 40, 42 assess is to be completed. So far as the 42 ingredient has been for the period 1/4/2011 to 31st March 2013. There was an 42 assessment prior to this. For that reason, this 43 assessment is justified for that period.
No, that's right. But he has challenged that separately.
That 42 has been challenged, and that is before the tribunal.
The 42 assessment.
42 assessment. That is so this 43, since your lordship is not accepting my submission.
No, on this fact, 43, you want to challenge it?
43 now challenging 43 1/4/2014 to 31/3/2015. That is on which that only they say the return has been accepted. And this previous period 1/4/2011 to 31/3/2013, that is 42 assessment tribunal. Then 43 is now common.
So that
Sir, this order for this period, what are you proposing to do?
Segregate himself.
For the first period,
yes,
1/4/2011 to 31st March 2013.
Automobile is not applicable to that.
So what else?
What do you want to do for this period, sir? For these 2 years?
For this period, will go in appeal.
Accordingly, for the said period, that is 1st April 2011 to 31st March 2013,
yes.
Counsel the petitioner seeks leave to withdraw this petition with liberty to challenge the assessment order in accordance with law. Consequently, for the said period, that is 1st April 2011 to 31st March 2013, the petitioner is permitted to withdraw the present writ petition to challenge the impugned assessment order. When the writ petition is in accordance with law, the writ petition is.
My lord, you recompute the matter because both the periods have mingled and made the demand common manner. Now, because 1/4/2011 to 31/3, that is to 2013, that is now in the tribunal, and 43 also there. But one for 2014, 31/3/2015, nothing has been done. Only 43 has been done. That has to be segregated.
Yeah, so only that we will interfere with.
You maybe recompute that period or segregate that, exclude that period.
That period.
As per Keshav Automobiles.
Yes.
Oh.
So that matter may be remanded to
Remanded to you for recomputation.
Your Lordship, what my submission, let this matter go to the assessing officer to restrict the assessment for the period 1/4/2011 to 31st March 2013. To restrict and pass a fresh assessment order for that period only.
All right, full stop. However, the demand raised as a result of the assessment order is combined for both periods. Full stop. Consequently, the matter has to anyway be remanded to the assessing officer for restricting the demand to the first period, that is 1st April 2011 to 31st March 2013, to enable the SSC thereafter to seek appropriate remedies in accordance with law for that period. Paragraph. As far as the second period, that is 1st April 2014 to 31st March 2015 is concerned, it is preceded by a self-assessment by the SSC under Section 39 of the OVAT Act. Full stop. According to the petitioner, there was no acceptance of the self-assessment by the department, and therefore the impugned assessment order for that period would be bad in law. Under Section 43 of the OVAT Act would be bad in law by virtue of the judgment of this court dated 1st December 2021 in STREV 64 of 2016, read with the subsequent order dated 8 April 2022 in STREV 64 of 2016, bracket Messrs. Keshav Automobiles vs. State of Odisha, which has been affirmed by the Supreme Court in Rati Steel versus State of Orissa.
SLP number.
That also must be a reported judgment by now.
That is reported.
No, Rati Steel would definitely be reported. Sir. Scale, no.
Lordship, SLP number 9912 of 2022.
9912 of 2022 in? No, Rati Steel is a proper judgment. It's not a paragraph. Rati Steel is full.
Order dated 13th July. 13th July.
13th July 2022 in SLP Civil also. I'm sure these are reported orders now. Find out the citations. Paragraph. Mr. Sunil Mishra, learned counsel for the department, produced before the court computer generated single quotes acknowledgement receipt, unquote. Dated the very same day the return was filed online by the SSC, that is 22/5/2014. So by referring to para 22 of the judgment in Keshav Automobiles, Supra, he sought to contend that the present case could be different from the facts in Keshav Automobiles because of the auto-generated acknowledgement receipt, which was not available in the aforementioned judgment, aforementioned paragraph. The court notes that the regime prior to the amendment to OVAT Act with effect from 1st October 2015 was that under Section 39 bracket 2 of the OVAT Act, as it stood prior to the amendment, there was a requirement of the department having to determine if the return filed by way of self-assessment was open quotation in order, unquote. Full stop. Section 39 bracket 2 reads as under 8 paragraph. Consequently, what is envisaged under Section 39 bracket 2 is not a mere computer generated acknowledgement of the return filed, but some degree of application of mind by the department to find out if the return filed is open quotation in order. Full stop. The computer generated acknowledgement produced before the court does not indicate if the department found the return filed by way of self-assessment to be open quotation in order. Consequently, the court does not consider this case to be different from the facts in Keshav Automobiles and holds that it is covered by the said judgment. Stop. Consequently, the impugned assessment order, as far as it concerns the period dated 1st April 2011 to 31st March 2013, sorry, 1st April 2014 to 31st March 2015, will stand quashed. Paragraph. The matter now is remanded to the assessing officer, that is the Deputy Commissioner of Sales Tax, Rourkela 2 Circle, to rework the demand by eliminating the demand as so far as it concerns the period dated 1st April 2014 to 31st March 2015 and confining it to the period 1st April 2011 to 31st March 2013. Stop. This exercise be completed by the AO within a period of 2 months of receipt of the present order. For this purpose, the matter be listed before the concerned AO on 1st February 2023, on which date the SSC will produce a downloaded copy of this judgment before the AO for the necessary steps to be taken by him. Paragraph, it is clarified that after the AO passes the issues the revised demand order, assessment order and demand, it will be open to the petitioner SSC to seek appropriate remedies thereagainst in accordance with law. The writ petition is disposed of in the above terms.
Obliged. All right.
All right. In the other matter, this 10347, you have to say this is under the OET Act, and the judgment referred to as ECMAS Receipts Private Limited, State of Orissa, 2000 AR 2022 Orissa 169. But that was not taken to the Supreme Court. ECMAS was not taken to the Supreme Court. All right. Okay. All right.
Obliged.
83.
My lord, 1 week time may kindly.
For what, sir?
My lord.
For what purpose?
I have to adduce some evidence.
Evidence?
Evidence.
In a writ petition, you can't adduce evidence.
No, my lord. The revenue had to file the counter.
2016 matter, sir.
16 matter. My lord, 1 week time.
What that, sir? Tell me. I'm also very curious to know. Why?
My lord, sole demand. Basically, disallowance of the capital goods of ITC. ITC on capital goods. My lord, for that reason, I have 1 week time.
Just tell me, sir. I'm very curious to know. You're not telling me the real reason.
My lord.
You have to urgently go somewhere?
No.
Tell us what the matter is. Ex parte corrigendum order of assessment is challenged. So you know what question I'm going to ask you.
My
lord. Why not challenge it by way of appeal?
My lord.
That is why you wanted 1 week's time. Because you know I'll ask you this question. And somehow this question will not disappear in 1 week.
This is one issue.
No, that is our issue. So you answer this issue. Then we'll go on to the next issue of yours.
Sir, while passing the corrigendum order, in the second writ petition bearing number 20991 of 2016, in original assessment, it has been imposed penalty 1 time. And in the corrigendum order, without issuing any notice and addition of another 1 time penalty, it equal to 2 times penalty, it has been challenged. It has been challenged without issuing of notice.
So you had a stay order that will continue till the appeal is decided. What more do you want?
My lord?
Anyway, I think anything that I ask, you're not able to understand. I'm going to ask Justice Raman to ask.
No.
Whatever I ask, you turn deaf. So let us see now if you're able to understand what Justice Raman tells you. All right.
In the appeal, you can raise this point.
My lord, appeal, I can raise this point. But
You can also
sole
decide
demand on
whether-
basis of the disallowance of the ITC, which I am eligible to take. And also there is one question here is that before issuance of any corrigendum order, he should have issued the notice. And it has not been properly issued. Not been issued, not properly, not been issued. And without issuance of notice, and my lord,
Every violation of natural justice is it writ remedy?
no.
You got the answer.
And there is some issue. My lord, I pray for 1 week time. There is some issue.
We have even more serious issues, sir. Both of us. We have very serious issue. We are not able to adjourn. Very serious issue.
And
unable to adjourn.
I have to amend the writ petition.
Not necessary, sir. For us, it is not necessary.
My lord, I am saying. Within 7
you
days.
woke up after 6 years to realize you have to amend.
No, my lord. Within 7 days, audit report has not been submitted.
No, for 6 years, you did not think of amending. So no problem. You say both all the orders and the challenge in these writ petitions are appealable ones. So consequently, the court is not inclined to interfere at this stage. Stop. Permitting the petitioner to challenge the impugned orders in appropriate proceedings in accordance with law. The writ petitions are disposed of. If the appeals against the impugned orders are filed not later than 2nd January 2023, accompanied by applications for condonation of delay, citing the pendency of the present writ petitions as the reason for the delay, the appellate authority will consider them in accordance with law. The court clarifies it has not expressed any view in the matter. In such event, the interim orders passed by this court in the present writ petitions will continue till such time that the appeals are disposed of, or the such order is varied in appeal and an application to be filed by the present petitioner. The writ petitions are disposed of in the above terms. All right.
My lord, original order may kindly be.
The originals be returned subject to being substituted by adjusted photocopies.
84.
So item 84 minutes. So may I pray your lordship minutes to kindly take up minutes the connected the WPC first with WPC number 6089 of 2019 minutes. That pertains to GST matter. Service tax like oh, so sorry. 84. Oh, sorry, it's all right. 690. Yes, I'm so sorry. So first matter is GST matter bills. Yes, I'm giving a copy of the judgment to the Honorable Apex Court bills. The question involved in this case is service provided by a person located in a non-taxable territory to a person located in non-taxable territory bills. Bills respecting transportation of goods by a vessel bills from outside the country belongs to a custom station in India for clearance. That is taxable
ocean-bearing vessels. That matter.
Yes, Mohit Minerals case. And my Lord Honorable Justice Raman has also authored a judgment pursuant to this Honorable Apex Court.
It's only order we have copied down from.
Yes. Paradip first. I am giving to yes. In Paradip first case, our High Court has also dealt with bloods and
So in view of the judgment of this court dated 1st August 22. In writ petition civil 1684 of 2019, bracket Messrs. Paradip Phosphates Limited versus Union of India. Liberty is granted to the petitioner to make an appropriate application for the competent proper officer in order to raise the claim for refund here also.
Yes, my lords.
In terms of the order dated?
That order date to be changed because in my case, my lord's entry order was 3/4/2019.
3/4/2019. In the writ petition, to the effect that open petition, any payment made by the petitioner will be subject to the result of the writ petition. Unquote. The proper officer shall counterfeit the amount in accordance with law, taking into account the judgment of the Supreme Court in Union of India versus Mohit Minerals Private Limited, 2022 SCC online 657. Post of the proper officer may examine the records of the petitioner and take appropriate decision within a period of 3 months from the date of production of a certified copy of this order.
So may I ask you, Lord,
along with the
to ask-
interest, because pursuant to that, Gujarat High Court, I'm giving those orders. They have also given statutory interest. So that may be incorporated in my lord's order. Paradip Phosphate doesn't take note of that, but that we are
Claim for refund together with interest.
Yes,
with it.
along with statutory.
Yes, sir.
Gujarat High Court has done it.
My second matter pertains to service tax.
This is in the first matter, 6909.
Yes. Second matter is 6089 of 2019. But the notification is identically worded. But service tax, as my lords know, service also comes under composite supply under the IGST Act, my lords. So therefore, it's identically worded. This is GST, that is service tax. And on service tax, my lords, now a judgment of Honorable Gujarat High Court has come. Separately, Honorable Court has dealt in. And also following that, my lords, Honorable Court has quashed those notifications. Only distinction that is GST, this is service tax. But
So
genesis
here
of
there's no
both are
question
same.
of going back. This is
No impact. Same impact, Virat. Impact is same.
no. This is not a question of refund then.
No, same thing will follow, Virat. The reason being, Virat, after GST, Virat, all goods and supply both are taken together for purpose of levy of tax on GST law, Virat. And prior to GST, only service tax was there. So the notification deals with only service tax prior to GST here. For 2 months only, barely for 2 months.
So no, for here also you'll go for the refund to the proper officer.
Exactly, Virat. Correct,
Alright.
Virat. In same terms, Virat.
What do you say? Who's for the department?
No, only thing I have the.
You have anything to say on this submission? Are you appearing for the department?
Yes, my lord, I am for the 7132.
Sorry?
7132.
No, who's appearing 6089?
My lord, I am.
All right.
I have one more information to share with my lords. In this case, Union of India has preferred SLP for the Honorable Apex Court. Honorable Apex Court has not stayed the operational judgment. The notice issued.
Gujarat
But
matter.
after- Yes, but after the judgment of Honorable Gujarat High Court and after the notice issued, there are 3 tribunals have also followed the same judgment. I have given all judgments to Lordship. So same thing will follow if they can approach.
Your Lordship, the order dated 6/4/2021, your Lordship may kindly look into. These cases have been adjourned sine die till disposal of the SLP before Supreme Court. Supreme Court, your Lordship, and accordingly interim order has been passed. I am arguing in the case 14456/2020. Your Lordship, in that case,
Service tax or GST? May I know, please, sir? Service tax or GST?
No, GST.
I am on service tax.
Acha.
No, I am on service tax.
All right. We say 6089. We say that challenge in this present petition is to a notification dated 13th April 2017 and a circular of the same date. In terms of which service tax is payable. On ocean freight for services provided by a person located in a non-taxable territory to a person located in a non-taxable territory by way of transportation of goods by a vessel from a place outside India to the customs station in India. Full stop. In respect of the demand of GST, on ocean freight, the matter is covered in favor of the SSC and against the department by the judgment of the Supreme Court of India in Mohit Minerals Limited. Sorry, Union of India versus Mohit Minerals Private Limited, 2022, SNC Online 6570. So as far as service tax is concerned, reliance is placed on the judgment of the Gujarat High Court in Sal Steel Limited versus Union of India, 2020/37 GTL3 (Gujarat), which answers the same question in favor of the SSC and against the department by quashing the very same notifications.
Fine.
Counsel, Mr. Sahul, senior counsel for the petitioner, points out that although the said judgment of the Gujarat High Court has been challenged in the Supreme Court of India by the Union of India by way of SLP Civil Diary number 27016 of 2020, only notice had been issued in the said SLP with there being no interim order staying the operation of the Gujarat judgment of the Gujarat High Court. Paragraph. In that view of the matter, following the judgment of the Gujarat High Court in Sal Steel Limited, Supra, this court quashes the impugn notifications at annexures 4, 5, and 8.
4, 5, and 8, madam.
8.
Yes, madam.
4, 5, 6, and 8, I think.
4, 5, 6, and 8.
Yeah, 4, 5, 6, and 8. The petition is posted off in the above terms. All right. Now, each of the others, 7132.
Please, my lord. Well, I'm appearing to the opposite party 3 in 7132. Another notification which has been challenged in this lead petition has no concern to the department opposite party number 3, my lord.
They already removed from the array of parties, my lords.
All right. At the request of counsel for the request of counsel, the petitioner, the opposite party number 3 is deleted from the array of parties. All right.
A small interruption, my lords. Also 13/4/2009, your lordships are entry border. 3/4/2019. The entry border which your lordship have passed, subject to outcome writ petition, for refund purposes, same model.
It will now be open to the petitioner to apply for refund.
My lords may
in accordance with law.
Pass a similar order as was done in the previous matter.
Delayed payment of interest, my lords,
as well as refund along with refund of the service tax paid along with statutory interest in accordance with law. All right. Yes. What is this matter about, sir?
7132. Same issue, my lords.
8283.
7183.
This is IGST now.
7132.
So same orders at Paradeep Phosphates.
Yes, my lords.
All right. So the same order is at first matter, which is 6909. Same order as that. The interim order date here will be 10/4/2019. All right. (8283).
Mr. Jana.
GST matter.
All right. Same order. I think the order of this court would be 16/5/2019. Next, visa amendment.
Yes, 11750. There, IGST, and the date of order would be 26/7/2019.
Right. All right. 26/7/2019. Right. Adani Wilmar.
Adani Wilmar.
Who's appearing?
I'm Harichandran. Mohit, it is a Paradeep Phosphates matter.
Sorry?
Paradeep Phosphates matter.
Who's for the petitioner? You're for the petitioner?
Harichandran.
No.
Your Lordship, please, Your Lordship, I'm appearing for the petitioner online, and the order should be similar to the PPL order.
All right. First matter
regarding to IGST.
My lords, if my lords may kindly take note. Am I audible?
There doesn't seem to be any interim order in Adani Wilmar. Just see, I don't think there's an interim order.
Your Lordship's right, the order that is 6/4/2021, your Lordships had directed, had adjourned the matter sine die pending adjournment before the Supreme Court, and had directed that the department may not make any recovery And our applications for refund are also
So
pending before
that
the
will be 11,121. 11,121. 14456 is what? Right. 14456.
There is IGST. That is GST matter, madam. Same for the first order dated is 6/4/21. That is internal.
So 6/4/21. Right. Visa min metal again,
Yes,
same thing.
Same order can be clubbed. Both can be clubbed together. This is IGST.
Okay. So 11750 and 28302 pass a common order.
Yes.
All right.
My lord, 7132, I'm appearing. So it's a IGST matter. Similar order may be passed in that one also, my lords. 7132. Where the respondent number 3 was deleted from the array of parties.
Yes.
Please, my lords.
Yes.
It's a IGST matter, my lord. Similar order may be passed in the.
Sir, I think we have already passed it, sir.
Please, my lords.
I'm sorry for troubling your lordship. That PPL order that can be repeated, but only thing is that statutory interest may be added,
Sure,
which
sir.
was not there in PPL.
No, PPL also we've added it, sir.
Yes.
So we'll just repeat the PPL order.
Yes.
No. What is he trying to tell me? All right. No, we only deleted it today. You mean by the time I dictated, he sent this? Today we've deleted, sir. Yes. Don't. What happened? 28302. You've already
over.
85.
Today you are filing the counter, man.
My lord, we permitted to file the regenders, my lord.
You have already filed the counter.
No, today we are
Today I
filing.
Filing. The counter affidavit of the opposite parties be brought in record, rejoined to be filed before the next date.
My lord,
Interim order to continue. List on.
My lord, similar matter is coming on 4th of April, my lord.
4th April. All right.
My
List on
lord,
4th April.
my lord, interim order will be continued.
I've just said that, sir.
Oblige, my lord.
86.
It's same. Today we are filing.
We have received the counter, your lordship will file that. Your lordship, the similar matters are coming on 4th of April. Your lordship will direct the interim order to continue.
Yes.
Published.
87.
May I presume. Now, based on the annexure 3, my lord, demand notice were issued under annexure 1, my lord. And in the meantime, this honorable court has already was the annexure 3 in its judgment that the 6034 of 2013, my lord.
The number कहला
64 इधर मोर
एक्सरसाइज नहीं
Repeat this order?
Yes, ma'am.
All right. Same order.
I am appearing for the department, ma'am.
All right.
Opposite part number 3.
All right. All matters.
All
matter.
All right.
88.
It is infectious, my lord.
It is post office infectious. All right.
89.
Both matters.
My lord, 89. Writ petition is regarding, my lord, refund of license fee and exemption of MGQ duty on account of closure due to order passed by the excise authority. Lordship may kindly turn to Annexure 3, page 14. My lord, second subparagraph. You are hereby directed to so cause by 22/9/2021 as to what circumstances your shop was opened over government land, temple land, endowment property, and why suitable action shall not be taken against you for cancellation of the license. The said shop should be closed with immediate effect. My lord, this is dated 20th/9/2021. My lord, may turn to the next page, page 15. Here, my lord, the Superintendent of Excise has issued a letter. They have stated that in continuation to this office letter under reference, you are hereby directed to find out an unobjectionable private land for shifting of your Marine Drive Road, IMFL off shop, and also submit the land particular house rents agreement such and such. My lord, then in pursuant to this letter, I had offered the land. My lord, when they approve the land, lordship will find that Annexure 6, page 17. Now, pursuant to the order of the commissioner, the Superintendent of Excise has passed an order approving the newly offered land, my lord. Now, I am seeking refund of license fee and exemption of MGQ duty. My lord, in the similar matter, your lordship has passed an order.
Waiver of license fee is not permissible, but so far as that return of the MGQ is concerned, that can
it is permissible. It has been dealt with, my lord.
License fee cannot be.
It is permissible.
Because for your fault, you could not open the shop. That I have filed.
This is not my fault. This is
not a government land. You only gave him license to go on a government land. Subsequently, you say you're on government land, you have to go.
Yes, they are litigating over that land, whether that is government or private, my lord. They are litigating.
Land of Lord Jagannath.
That has not reached the logical end, my lord. They are litigating. Whose land it is? Sir.
Yeah, both MGQ and license fee both have been considered together.
My lord.
Government to consider. The first order, your lordship may kindly see.
And subsequently, I have given all the order in the case of
that. All are remand cases.
No.
That your lordship has directed the government to consider. The first order may kindly be seen. WPC 7490 of 2021. The first judgment he has relied on.
So, permitted you to make a representation for refund.
As your lordship.
That's better. You see,
my lord, I will file a
in view of the orders passed by this court in Suresh Chandra Mishra of the state of Orissa, 2016, 121 CL 587. Court permits the petitioner to make a representation to the respondent authorities for refund of MGQ and license fee for the period during which the petitioner's shop had to be closed. If such representation is made not later than 2nd January 2023, the superintendent, is it?
My lord, the government will consider. Government will consider.
The Secretary, Department of Revenue,
OP1,
will examine such representation and after giving the petitioner a hearing, dispose it off in accordance with law within a period of 2 months thereafter.
My lord, if at all I am aggrieved, it will be open to me.
Yeah. 3 months later. If the petitioner is agreed by such, the order will be communicated to the petitioner within a week of it being passed. If agreed by such order, it will be open to the petitioner to seek appropriate remedies in accordance with law.
My lord may just only indicate that taking into consideration the previous order passed by your lordship. And
no, we said Suresh Chandra Mishra. That same order is followed in all those bunch that you've said.
90.
May I please, Lordship? My Lord, the petitioner running a hotel and made application for running for IMFL on shop, but it was rejected on the ground that it is coming within 220 meters of the national highway. My Lord, it is the area is we coming within 3 kilometers of the outer limit of municipal area. And earlier, the apex court has modified the earlier order and stipulated that, my Lord, I am reading the relevant portion. No shop for the sale of liquor shall be visible from a national or state highway, directly accessible from a national or state highway and situated within a distance of 500 meters of outer edge of national or state highway or of service lane along with the highway. In the case of area comprising local bodies within a population of 20,000 people or less, the distance of 500 meters shall stand reduced to 20 meters. My Lord, my hotel is located within outer side of the municipality, that is within 3 kilometers. And earlier, also the state has also allowed license holders to operate. My Lord, kindly see Annexure 4 as page 20. Retail liquor outlets may be allowed to operate along the highway within 3 kilometers from the outer limit of the municipal corporation municipality, provided the area is sufficiently developed as urban area. The field situation will be in.
So, which municipal corporation are you under?
My Lord, Sambalpur Municipal Corporation.
But there's a letter, 30th November 2021. Have you seen that? It's an annexure A5.
My Lord,
see annexure A5, sir.
My Lord, kindly see my rejoinder. Annexures.
No. First you see A5 and then we'll see whatever you want us to see. Come to annexure A5.
What is the impugned order that is not borne out from the record? Which order he is challenging? The government's order?
My Lord, I have at that time when the petition was filed, they have recommended for rejection.
Where is that? Annexure?
My Lord, annexure
8.
Annexure 6.
6.
Application to DEDC for section of the collector Sambalpur has submitted a proposal for rejection of application of Sri Natwar Kumar Banka.
If it is the order of the excise commissioner, that can be challenged before the government. That is not the final authority. Government is there. Government can also set aside this and grant you license.
My Lord, I have no objection if.
Counsel for the petitioner seeks leave to withdraw the present petition with liberty to approach the Secretary, Department of Revenue.
Secretary, yes, madam.
For challenging the order dated.
That is what also I am not.
The 8 is what?
Annexure 6.
6.
So what is Annexure 8?
Annexure 8 is a letter recommendation. Annexure 8 may be.
My Lord, Annexure 8 is the recommendation of the collector. That merged with the recommendation of the excise commissioner. So he has to challenge the excise commissioner's order.
Order of the excise commissioner recommending rejection of the petitioner's application for an IMFL on shop in accordance with law. If such on shop full stop, if such representation public application is made not later than 2nd January 2023, the Secretary, Department of Revenue will come after hearing the petitioner. Department of Revenue or
yes,
excise?
Department of Excise.
Excise. My Lord may give some more time because now so many matters are being remitted back to this excise. Virtually he is holding court twice a week for all this.
Not later. We'll pass a reasoned order not later than April. 3rd April.
Yes.
3rd April 2023. And communicated to the petitioner within a week thereafter. If agreed by such order, it will be open to the petitioner to seek appropriate remedies in accordance with law. The court clarifies it does not explain the matter.
Item 71. Item 71, there is an excise matter of Mr. Rathod. Only the Lordship will issue notice to the private opposite party is there. He is challenging the government's order. So notice will be issued. I will file counter. Item 71.
All right. Say notice, Mr. Mohanty accepts notice for opposite parties 1 to 4. Notice to opposite party number 5, returnable 4th April 2023. The tracking report will be placed in record.
Passport matter. Item 36.
My lord. In this case, though the petitioner has a defect, they remove, but the receipt is not. This therefore as per the order of this, the deputy registrar has dismissed the case, and after querying and knowing this, the CMPL is filed, and within that 186 days is delayed. But the crux of the case is different, my lord. There is a vital point. The petitioners are coming to this honorable court. Only they are discriminated because the government has floating 2 schemes for the crop insurance, my lord. The petitioners are the farmers. Their point is that they have categories 2 types. One is loany farmers, another is non-loany farmers. Loany farmers are bound. They have to cover under the, they have only weather-based crop insurance they will do. And the non-loany can opt 2 things. Maybe weather crops or millet, that is the NAIA scheme, that is the National Agriculture Insurance Scheme. The difference is that these 2 schemes, both the premium is same, my lord, 300. But those who have opted the loan is compelled to do WBCIS scheme, they only get the premium, only get the per hectare 280. But the non-loan who opt the NAIS scheme, they are getting rupees 13,885. So this is the discrimination, and the farmers are belongs to the KVK groups.
What's the reason for the delay?
My lord.
What is the reason for the delay?
My lord,
186 days.
My lord, the serving the copy in time when this honorable court directed to remove the defect. But the receipt, the clerk is not attached to that. And as per this honorable court's order, deputy registrar has so moto dismissed the writ petitions. And when the present petitioners filing the memos, matter could not listed and query what is the status, thereafter found that the matter is automatically dismissed and CMPL is filed. In the meantime, 186 days is delay, my lord. Only communication gap between the advocate's clerk and advocate, my lord. Nothing by the petitioners.
All right, so for the reason stated therein, the office order dated 15th April 2014, 15th May 2014 is set aside, and petition civil 29335 of 2013 is restored to file. And then that 29335 of 2013, so today the matter has been restored by virtue of the order passed in the same APL. The petitioner's representation, I think that's best, dated 10th August 2012. So you make a fresh representation, I think.
Hello.
Who's going to trace it out? You say the counsel, the petitioner seeks leave to make a fresh representation to the opposite parties. and after following up on such a presentation to seek appropriate remedies in accordance with law, disposed of his withdrawn with liberties paid for. All right.
53. Item number 53.
Let's that gas discount. Gas discount. Let's see. That.
In which one? In this one. Ah. Just see this. It's not. Just see the questions. Not the same.
This is entry tax. From sale price, deductions are made. Discount has been deducted. So whether trade discount and other discounts are eligible under 2H for the purpose of levy of entry tax. That is it. But here, this court held that trade discounts are to be deducted.
Trade discount. Your Lordship, trade discount, Your Lordship.
So I think that is the issue here also.
As Your Lordship pleases. As Your Lordship pleases.
The issue sought to be urged by the department in the present revision petition is whether single quotes quantity discount, special cash discount can be treated as single quotes trade discount and can be allowed to be deducted from the turnover under the Sales Tax Act 1947 (OST Act), and consequently the corresponding levy of entry tax on the amount of such discounts can also be deleted. Paragraph. The issue appears to be covered against the department and in favor of the SSC by the order dated 14th August 2019 of this court under petition civil 1566 of 2006. Bracket Messrs. SEAT Limited versus Commission of Sales Tax. In that view of the matter, the court is not inclined to entertain the revision petition and it is dismissed as such.
Lordship, in kindly pardon me, notes. At this hour, my lord, I should not be disturbing your lordships. This item 72, your lordship directed me to pay that amount, my lords. Unfortunately, the tribunal's order, my lord, has the it has been remanded back to the assessing authority. So there's no demand as such. I'm only challenging the findings of the tribunal, my lords. The findings of the findings of the tribunal, my lord, is being challenged. The tribunal, my lord, on a wrong premise, my lord, has set forth.
Maybe the tribunal has decided the matter by now.
No, no, my lords. The reassessment proceeding has not begun. It has not concluded, my lords. That's why, my lord, I was pressing, my lord.
9 years.
It's still pending. It's the OST period. It's still pending.
No. If it's remanded by the tribunal to the
it's remanded by the tribunal with certain directions
to the assessing officer.
I challenge those directions before your lordship.
Not by the tribunal. It has been remanded by the first appellate.
No, my lord. Let me place 74, my lord. In view of the discussion, sir, the case is sent back to on remand to this learned STO for a fresh assessment in the light of our observations above. In the result, the appeal is dismissed and the orders of the learned
AC. So why should we challenge?
Because these observations, unless these observations go, my lords, again the assessing authority will serve.
No, then you should have filed a revision if it's a tribunal's order.
No, I have, my lord, I have come up before your lordship, my lords, raising these questions of law, my lord. Whether, my lord.
No, 74, which is this item 70?
Item 72, my lords.
72. Achha.
So this, at page 74, what they have done, my lord, is they have treated me as an expansion unit, even though, my lord, it's a diversified unit, my lords. Page 74 of the, your lordship may kindly see, my lords. The last paragraph 19. So these observations have been challenged in this tax revision, my lords, where they have equated me, a diversified unit, as a expanded unit, my lords. As only humbly praying, your lordship may just modify that order about payment, my lords. Then the lordship may issue notice, let my learned friend reply.
But first appellate order, the last page is 6.2.
That is against me. That is against me.
In that case, the first appellate authority has set aside the matter. Both the period, the first appellate authority has set aside the matter to the assessing officer for fresh assessment. Tribunal has also confirmed that. Your lordship, against that first appellate authority, your lordship for the last year, the petitioner himself withdrawn.
Your lordship will call it on some other day.
I have given that order. I have submitted that order last day.
So your appeal is dismissed by the tribunal?
Dismissed by the tribunal with certain findings. I chose findings before your lordship's, my lord. And the additional ground, my lord, is my contention before the first appellate authority has been allowed in 96, 97, 98, 99. But for 97, 98, my lord, they come up with another finding and they remand the matter back. And those findings are before your lordship, my lord.
So, okay, just that order, just say whichever the date is, which is the issue notice returnable on that date. That's all.
My lord.
All right.
Greatly obliged, sorry for disturbing your lordship.